Right, good morning, everyone.
I'm lost. I haven't got the screen.
We can see you, Christopher.
I can't see any of you.
I can see
can
you.
now. I can now. Right. Okay.
Okay. Good morning, everyone. This is the Court of Appeal for Bermuda convening at 9 o'clock in Bermuda to hear the appeal number 11 of 2021, the Corporation of Hamilton against the Attorney General and Minister of Legal Affairs and Constitutional Reform and the Governor of Bermuda. I will open it to the parties to establish the representation.
May it please the court. I am on the screen. I see I'm called Harish Salve.
Yes, that confused me slightly.
Who is a very distinguished colleague of mine, but my name is Jeffrey Joel, and I appear for the Corporation of Hamilton with my learned friend Ronald Myers, who's in Hamilton, with Mark Deal of Marshall, Deal and Myers, and for the respondents, also in Hamilton, are Delroy Duncan QC, Ryan Hawthorne, and Lauren Sadler Best of the Attorney General's Chambers. Ryan, they're of Croft and Duncan Limited. I also have with me Tom Lowenthal, who is a junior barrister who is in Blackstone Chambers, where I am, but is not instructed in this case, but is, with the court's permission, simply attending. We understood that this would be permissible since he might be attending in any
public hearing. Anybody can attend.
Indeed, my lord. Yes. My lord, my lady, my lords and lady, as the court knows,
Professor Joel, you don't need to refer to me separately. Just call me my lords, okay? Otherwise, we just waste time.
Thank you. Shall do. As you know, my lords, we were all intending to be in Bermuda, but events conspired otherwise. We have a line open if there's any need to take instructions at any point, if the court will allow. If I may start with the new point relating to free expression in respect of the abolition of the present democratic electoral system at the local level. We obviously raise this new point advisedly, and after due notice, the respondents received our skeleton submissions on the 20th of August on this point and responded in his skeleton submissions.
I wonder if I can cut you short in relation to this. We've considered the somewhat lengthy correspondence between the parties about the freedom of expression point, and the view that we have provisionally reached, subject to being persuaded that we should do something different, is that we should consider the matter de bene esse, that is to consider what the parties have to say about it, on the clear understanding that if we come to the conclusion that the matter can't fairly be dealt with without further evidence that wasn't before the Chief Justice, we shall decline to entertain the point. It seems to us rather difficult to address that question without going through the merits.
Indeed, my lord, and certainly I'm very content with that approach, and we'll then start on that point right away.
Is it wise to start on your last point first?
My lord, this is a such a fundamental constitutional point. One of the
I'm
points
slightly
that I
surprised
made-
by that. If it was such a fundamental constitutional point, why wasn't it argued first time round?
Well, should I say first of all that I did not argue it at the first instance. I have full confidence in those who did, but perhaps it wasn't that apparent, or perhaps it. I really cannot
Okay.
answer that
Well,
question.
I mean, it's subject to Mr. Duncan seeking to persuade us that we shouldn't hear what you have to say de bene esse. You must take your own course as to which point to start with. Mr. Duncan, would you seek to persuade us that we shouldn't consider matters de bene esse?
My Lord, I am concerned about wasting the time that we have because there is a plethora of issues to deal with. However, in my view, there is a complete knockout point to dealing with this matter, and whether the court wants to hear it now or de bene esse is a matter entirely for the court and in the court's hands.
Well, I think we will deal with it as it arises. But you want to start with it, do you, Sir Geoffrey?
Well, my lord, I was hoping to start with it simply because for us, this case raises fundamental constitutional questions. And if I may expand on that just for a minute, the Chief Justice very much located this case in the realm of ordinary legislative regulatory activity, not willing at all to intervene in anything that he regarded as political. And in that way, I feel that the whole judgment rather skews the issues away from the constitutional into the area of political opinion. One side says one thing, the other says the other. I as a judge, don't really want to intervene. And I think the reason that we raised that constitutional point, and another one having to do with the rule of law, is that we believe that this abolition of this ancient local authority, going back over 300 years, not always behaving perfectly, no central government or local authority always does, but certainly seemingly on an even keel now. To abolish that authority is a major step. Now, it is true that there is no right to local government in the Constitution, but the principles are such that to me, they really stand out in this case. And I would not like to dilute it, in a sense, into a case simply about one opinion versus another ordinary administrative regulation. It is not. And that is what I want to establish right at the outset. And that was the reason for raising this point. The abolition of elections, the opportunity of people who have been residents in the Corporation of Hamilton for generations, now being told they must accept a centrally appointed body that is going to decide that is going to express their so-called voice, when there will be no direct voice whatsoever. That is the reason that I'm trying to locate this matter much more in fundamental constitutional principle, and indeed human rights, the rights of expression in this particular case, the rule of law, rather than simply that of a matter of ordinary public administration. But I'm in your hands, my lords, and if you prefer me to start where exactly in the same way as the case was conducted below, I'm certainly prepared and ready to do that.
Well, I think that would be helpful, really.
My Lord, I shall begin then with the question, the age-old question of whether Section 1 of the Constitution is, sorry, I'm just looking for my, the Bermudan Constitution. It is here, I know, but I wasn't preparing to get to it quite as early. So I ask for your indulgence for a very short time. Sorry, I'm just looking for the Bermudan Constitution.
Yes, it doesn't seem to be in the bundle of authorities, which is rather curious.
Yes, in which we asked, we wondered about that and suggested it be sent to you yesterday. You received a bundle yesterday, Lord, which in any event, the relevant section is certainly set out in the judgment.
Yeah.
So we can do it from there. There's no problem about that.
But that does, of course, Sir Geoffrey, only set out sections 1 and 13 and not section 9.
Yes.
So we have to go to your argument for section 9.
Yes, which was before me. Oh, here it is. Sorry, it's in the bundle of the municipality. I have it. Right. My Lord, I have it before me. Thank you. My apologies.
No, don't worry.
The issue of section 1 is important because it concerns the question of whether deprivation of property through regulation, as it were, rather than through direct expropriation, might provide an entitlement under the deprivation of property without compensation provision in section 1C of the Constitution. And it also invokes what we say is the rule of law, in the sense that section 1A provides a right to the protection of the law, although we also say that the rule of law probably inheres in the Constitution in any event, as it would in any democratic constitution. Now, my Lord, I'm fully aware that many others over the years have interpreted this section, and perhaps this court has been taken through it often enough. But I would like to look at it just for a moment in a certain amount of the words, in a certain amount of detail, because I do believe that over the years, various judges have simply focused on the word whereas, with which the section begins, and have regarded that as a preambular message rather than anything substantive to follow in that section, or much to follow. But if we start with the word whereas, as has been done so often, we would submit that this word heralds, in a way that any new transforming constitution at the time of independence heralds, the fact that this is a limited rights-based democracy and not the former kind of democracy which was totally followed the model of sovereignty of parliament. It's a limited constitution, a constrained constitution, because it says, whereas every person in Bermuda is entitled to the fundamental right. So there is an entitlement immediately. That is to say, has the right, and there is the word right, whatever his race, place of origin, political opinions, color of the creeds, and sex, and so on. And then goes on to say, to each and all of the following. And you may have the catalogue in sections 1A, B, and C. It seems on any analysis that this section, whereas is the declaratory phrase rather than at all aspirational or preambulatory. And in any event, for those that know these kinds of constitutions, there are very few even preambles that begin with whereas. They often begin with we the people and such expressions. So continuing, it then continues to set out the individuals who actually possess the right, each and all of those rights. And it says that the subsequent provisions of this chapter sorry, I beg your pardon. I think one also has to look at the question, there is a right, whatever his race, place of origin, political opinions, color, creeds, or sex. That again qualifies the right, that it is intended to be implemented in respect of equality before the law without any kind of discrimination. This defines that these rights are to be applied themselves in a particular way, subject to respect for the rights of, and freedoms of others and for the public interest. Here, the right is limited, an initial limitation for the freedoms of others and the public interest. So this is a classic grant of a right that is set up as a right, as an entitlement, and immediately qualified in the way that it can be implemented. It must be implemented without regard to discrimination, and then limited. So there's some detail given to a right. It's not purely aspirational or preambulatory. There's some detail attached to it. The section then continues to indicate that the subsequent provisions of this chapter will have the purpose of what? Of affording protection to the aforesaid rights. Again, rights used for the third time. These are rights. And in the subsequent sections, we are going to afford protection to those rights. This isn't a section that cancels. That isn't a phrase that cancels the rights and says, these rights here, we just put them as in a preambulatory way, and they're going to be enforced at some simply basic principles or objectives. But on the contrary, it seeks to endorse them and require them to receive positive information in implementation. For example, in the later section 15, by requiring them to be enforced in the courts. And then it provides affording protection of the aforesaid rights and freedoms subject to such limitations. It mentions the limitations of that protection, as are contained in those provisions, being limitations to desire that the enjoyment of the said rights and freedom does not prejudice the rights and freedoms of others in the public interest. And then we go to those following sections and we see.
Before you do, Sir Geoffrey, could I just ask you, I mean, don't the words, the subsequent provisions of this chapter shall have effect for the purpose, etc., doesn't that suggest that section 1 does not have the effect?
No, my lord, because the subsequent sections perform a different function. They set out a number of particular rights in much more detail, and they have tailored limitations attached to them. Section 1 has a general limitation, which is that it is there subject to the rights and freedoms of others and for the public interest, to each and all of the following. So there's a limitation under section 1. And there's also a positive indication in respect of section 1 that it should be applied without race, etc. The indication of subsequent provisions simply says that the subsequent shall have a purpose, and they shall afford
shall have effect for the purpose, not shall have a purpose.
Shall have effect, the subsequent have effect for the purpose of affording protection to the aforesaid right. So they are going, such as section 15, which provides for access to the court to enforce the rights there. Effect for the purpose of affording protection, of endorsing them, of making sure that they have an effect. And then, but subject to any limitations of that protection as are contained in the provisions. And then the subsequent sections all have a limitation clause, except the section 3, protection of inhuman treatment, torture, inhuman and degrading treatment, which initially did also have a limitation clause in respect of capital punishment. But in the 90s, that was, after a referendum, that was amended.
So Geoffrey, please may I ask a question?
Yes.
It's a rather boring grammatical question, but can you explain to me how a clause, which is clearly a subordinate clause, beginning whereas every person, which is the recital on which you really have to rely, how that can be construed as some operative provision of the Act?
I regard whereas is a word that in this context, I think it has to be seen in context as the answer to that. It's a declaratory word. It's one of those words that you see in new constitutions, indicating this is a new area, a new era. We proclaim a new deal. We're now moving into a rights-based democracy. Things won't happen in the way they happened in the past. And right at the outset, we say to you that you are entitled, and we are giving you these entitlements immediately. I see it as a proclamation, a ringing endorsement of a new era, rather than any indication that we're not really giving you what we say we're giving you here. Why would you have to say it in the first way? Why not just plunge in and leave out one and just go on to the rest of them? These are your rights. It must have a meaning. The trouble has been taken by the draftspeople, surely here, to carefully delineate what the essential rights are, to indicate that they must be applied as perhaps they hadn't always been applied in the past pre-independence situation, without regard to race, etc. But they are not absolute. They are limited. To put it awkwardly, why would they go to the trouble of providing the limitation at the top of section 1 and refer to possible discrimination if it didn't mean something, if it wasn't intended not to be a dead letter? And a dead letter is the kind of interpretation that has been placed on this section in so many cases. And our submission is that you are entitled to restore it to its original intention, and in the line of cases which we think simply allow you to do so in terms of precedent. That is the point.
Thank you. Thank you.
How does it work? Assume for a moment you're right. It follows that one of the fundamental rights given on your basis is the right of freedom of expression. That's 1B. Does that mean that somebody can say, I have a right of freedom of expression under 1, and I don't care what the limitations are under 9, I've got a right of freedom of expression under 1?
I think I would answer that by saying that some, but not all of the rights that are given under 1, these are the sort of fundamental rights. And again, I say, because they're so fundamental, they ought to have be taken even more seriously, perhaps, than those later. But some of them are adumbrated further on with in order to provide further limitations. And I would say that expression is one of them. It is given here because it is, some would say number 1 right, after perhaps life and liberty, and then protection of the law, due process, the rule of law. But it is simply further developed. Perfectly possible to do that under the
Sorry,
second
I'm not
restriction.
quite sure what the answer to my question is. I take the answer to my question, your answer, to be taking freedom of expression, that although 1B refers to freedom of expression without qualification, if you seek to assert that you have a right of freedom of expression which has been broken, you have to bring yourself within 9 and not within the exceptions to 9. Is that right?
I think that, to some extent, I think that it expresses it because expression is not. Yes, I would accept that, and I would say that that's put far better than I put it. Thank you. But I would say that other clauses there either have their own independent legal force, constitutional force, such as perhaps the protection of the law, and in respect of property, I would say it does go further here because it refers to deprivation and not merely expropriation, which is in the subsequent section. If, in other words, if nothing more is said, and if there's no difference between this and the subsequent section would prevail. If there is a clear distinction.
Well, the draftsman, on one view, could scarcely have been less helpful. He puts in a whereas in other versions of the Constitution, there isn't a recital type word. And on this analysis, he provides that freedom of expression is subject to the in effect, is subject to the limitations of Section 9, but the protection of the law isn't subject to, I think, any of the following sections. And there's a separate protection from deprivation, which is not subject to the provisions about the compulsory taking of possession or interests in. It's a very funny way of going about things.
My Lord, it just seems that this section seems to proclaim some fundamental rights and has set them out as entitlements to be granted to each and all of the following. There is nothing apart from the word whereas that indicates that it shouldn't have force and effect. The subsequent provisions shall have effect for the purpose of affording protection to the aforesaid rights. The aforesaid rights.
Well, that could be interpreted as meaning the subsequent provision shall have effect for the purpose of affording protection, but not the existing provision. If you say that your rights will be given effect to by sections 2 and following, that might mean that they're not being given effect to by section 1.
My Lord, protection to the aforesaid rights and freedoms, subject to such limitations of that protection as are contained in these provisions. In other words, what it clearly says is that we have given a very general limitation that deals with the question of limitations and protection. We've given a very general limitation here, respect for rights and freedoms of others and for the public interest. But indeed, subsequent provisions shall, in effect, provide, will protect the rights, but may provide some additional protections.
Yes, I can see what you say, but when you say the subsequent provision shall have effect for the purpose of affording protection, we have to understand, if what you say be right, that that's maybe so, but the existing, the first provision of the chapter shall also have effect for the purpose of affording protection to the aforesaid rights and freedoms.
Indeed, I mean, the first section, it requires protection of the first section, such as, if we look at section 15, if any person alleges that the foregoing provisions of this chapter is being, or is likely to contravene the foregoing provisions, no exception therefore, section 1, in relation to him, then without prejudice to any other action, that person may apply to the Supreme Court for redress.
I mean, that's your real point, isn't it, Sir Geoffrey? You say section 15 essentially envisages the inclusion of the declared rights under section 1.
That's exactly my point. Subsequent provisions will add to the protection, will make sure that they are not simply a dead letter, and that they will come to life and people may enforce them and implement them. In other words, this isn't a mission statement. It's far too well crafted to be a mission statement. Compare this to various preambles, nothing like them.
Right. So would it be sensible to look at the authorities?
Yes, indeed. We'll turn now to those. Well, first of all, I would say that the respondent's skeleton contends that it is too late now to redress any possible past errors of interpretation. And there are three reasons why we cannot accept that. First, because it is important to the integrity of legal reasoning to rectify any past errors or misunderstandings. Secondly, because it does throw up anomalies. We've looked at that now. That could exclude, for example, could exclude from the Constitution fundamental legal principle such as protection of the law, due process, the rule of law, and we would say also property deprivation short of takings. They could be excluded from the Constitution, from protection entirely. And this is, I think, important. And finally, and this I will show, is that because in any event, it seems that the prevailing wind is in favor of direct interpretation of the opening provisions due to the incremental development of constitutional law in democracies and in favor of a broad, generous, we set out our view about constitutional interpretation, broad, generous and rights-affirming interpretation, and not a narrow and rights-denying interpretation, if at all possible. And we agree that interpretation is not divination and mustn't distort the meaning. But I would submit that on any reasonable interpretation of Section 1, we are not at all distorting the meaning. In fact, we would say that it has been distorted in the past by this obsessive, if that's not too high a word, but concern for one word, the word whereas. Now, my Lord, I certainly don't wish now to take the court through each of these cases from the outset in painful detail, and would refer you to our written skeleton submissions for that kind of detail. And indeed, the Chief Justice has also outlined at least the gist of a number of the cases. So I would refer you to our skeleton submissions from paragraph 18 on, which asks first whether this court is bound by precedent to find that Section 1 is directly enforceable or not. And I would refer you to the Chief Justice's judgment, which deals with this in his judgment at paragraph 46 following. But the controversy, of course, begins in this odd way with what we say was a complete obiter decision of Lord Morris in the case of Olivia and Buttigieg in the Privy Council in 1967. And that's outlined in the judgment at page 1214, 1214, where he says, the judgment,
sorry, which paragraph of the judgment?
It's paragraphs, I'm so sorry, it's paragraph 51 of the judgment.
Yeah.
On page 1214. Where George, Justice of the Appeal, refers to the passage in the judgment of Lord Morris, who says, "It is to be noted that the section begins with the word whereas, though the section must be given such declaratory force as it independently possesses." So he does accept that, and this is often forgotten, that he did say that the section must be given such declaratory force as it independently possesses. It would appear in the main to be of the nature of a preamble. It is an introduction to, and it's in a sense prefatory or explanatory note in regard to the sections which are to follow. And he calls it a...
Excuse me, are we reading Ferris or Olivier?
We're reading from paragraph 51 of the Chief Justice's judgment.
Yes.
Thank you.
He calls it he says then, it is a declaration of entitlement. And this is, he's reading the Malta Constitution, which is the same, coupled, however, with a declaration that though every person in Malta is entitled to the fundamental rights and freedoms of the individual, yet such entitlement is subject to respects for the rights and freedom of others in the public interest. And then the section appears to proceed by way of explanation of the scheme of the succeeding sections. Again here, I think that some of the judgments of the past have simply focused on Lord Morris's use of saying that the word whereas it appears in the main to be in the nature of the preamble, but he also says very clearly that it must be given such declaratory force as it independently possesses. Irrespective of that, it was in the case of Farias and Maltas, which
So
is
just pausing there, what's I think it's common ground that what Lord Morris said in Olivier was obiter.
yes.
Yeah.
We would absolutely say it was obiter. This is a central part of our argument, that this was simply obiter. And so we would turn to tab 10.
Yes.
The case of
Farias or Farias.
Farias.
Pronounced Ferris in Bermuda.
Ferris.
Ferris. Thank you. In this case, in the Court of Appeal of Bermuda, for Bermuda, George J. did actually say sorry, George J. at page 10 of the judgment cites Lord Morris's words. He then goes on to say at the bottom of the page that this is similar to the conclusion reached in Societe United Docs and others. And then he goes on to, I'm so sorry. Anyway, he goes on to provide that the section 1 was enforceable. This was the banning of the fish pots case, and he tells that it was enforceable. So although he does cite the Olivier case, he reaches in effect the opposite conclusion and comes to the view that this is an enforceable, that Section 1 is an enforceable provision.
But wait a moment, do you accept that Olivier decided that it wasn't enforceable?
No, we would say this is an obiter.
Well,
But
yes,
wouldn't it be helpful, Sir Geoffrey, to have that as a starting point to see what the effect of what Lord Morris said in Olivier was?
Yes. I'm sorry. Could you
very honest with the position. In Olivier, there was no claim for an independent right under Section 1. The claim was on other sections. However, in giving his judgment, Lord Morris began, perhaps not surprisingly, with Section 1. But he didn't have to decide whether Section 1 gave an independent right, because nobody was relying upon Section 1. What he said has been interpreted, stroke misinterpreted, as saying that there was an independent right, which appears to be how it was interpreted by Georges, Justice Georges, or that he was saying was that it didn't have an independent right. That's the position, isn't it?
Yes.
Right. So Justice Georges relies upon what was said in Olivier, which was on any view obiter, and comes to the conclusion that there was an independent right.
Yes.
Is that ratio?
When you say he relies on Olivier, he cites the Lord Morris's statement at page 28 of Olivier, and then goes on to, it doesn't.
Well, he recites it, and then he says, Section 1 of the Constitution of Bermuda thus declares, thus is a reference to what Lord Morris was saying in the immediately preceding paragraph, isn't it? I mean, what's the point of citing Lord Morris if it doesn't have any bearing on the question that the judge was deciding?
Indeed, this is precisely what happened. Section 1 of the Constitution thus declares the right of the individual not to be deprived of his property without compensation.
Right.
He cites Lord Morris, but I suppose he must focus much more on the issue of whether the section must be given such declaratory force as it independently possesses.
Yeah. So with assistance from Lord Morris, as he takes it, he decides that Section 1 does give an independent right.
Yes. Yes.
Is that ratio or not?
That is that is George's ratio is that it gives an independent right with the assistance of Lord Morris.
Yeah, that's what I understood you to say. Just help me on this. What George has decided was that Section 1 did confer an independent right, but he also held that the terms of the section had not been offended, had not been contravened. That's right, isn't it?
Yes, that is correct.
So was the decision that the section did confer an independent right necessary for the result in that case?
Well, it was certainly, it was to this extent that in terms of application of the law, it was considered to be the law. But the facts in terms of whether it was going to give rise actually to a right itself was not applied, was denied. You simply apply. It's a clear statement of of law, that it does have independent right.
Yes.
Yeah.
So the fact that on the circumstance that on the facts the claimant wasn't going to succeed, whether or not Section 1 conferred an independent right, didn't mean that his decision that it did confer an independent right was obiter.
I think that his decision was necessary. The decision about Section 1 was necessary for his decision. But in fact, as applied to the fact, as that it's a statement of the law, when applied to the facts, the facts didn't come up to the standard of the law.
The reason that I'm asking these rather basic questions is that there seems to be a potential ambiguity in whether the test is what the test is about ratio, and whether it's necessary for the decision or necessary for the result. Because in this case, if he had held that there was no independent right under Section 1, the result would have been the same. The claimant would still have lost.
Yes. I think the question here is whether I would submit that the statement about Section 1 by George's, J.A., was necessary for, was simply a clear endorsement at the level of the Court of Appeal that despite the dictum of Lord Morris, Section 1 is independently enforceable.
Sure.
And that to me is the ratio of this case.
Right.
Necessary for the decision, although not necessary for the result.
Right, thank you.
My Lord, we could go through all these cases, and we could end up by taking the good part of the day doing so. I'm very much in your hands, but my submission is this, that both skeleton submissions and the judgment deal with them in sufficient detail. And I would submit that that in the last 5 or 6 years, there has been an alteration, a change, and certainly the Privy Council, in 3 cases that I would like to show your lordships, has now come to the view that the equivalent of Section 1 is directly enforceable. There are other dicta to the contrary. We cannot deny that is so. But looking at the matter chronologically, I would ask you to look at tab 15, the case of Neves on appeal, which is not a Privy Council case, but would lead into it. It's in the Caribbean Court of Justice. And
the Privy Council case is obviously very important. Can I give notice that there is a matter that concerns me? You say in your skeleton argument that Farias was part of the ratio. I follow that. But you also say that because it was part of the ratio, we are bound to follow it. And you then say that the subsequent decisions of this court on the topic are not part of the ratio. I give notice that I may require some persuasion in relation to that, certainly in relation to Inchcup and possibly Ferguson, because it seems to me at first blush that if, as you submit, the decision about Section 1 in Farias is part of the ratio, so it is at any rate in Inchcup and probably in Ferguson. Now, I don't want to take you out of order,
Yes.
but I give notice that if you say that we are bound by Farias, and that the other cases are all ratio, the other cases of this court are all ratio, I may need some persuasion.
Yes. May I refer you to, at this point then, to deal with that just as a, looking at it in the round, page, paragraph 20 of our skeleton submissions.
Yes.
Which sets out our position as clearly as we can. This is on page 10, paragraph 20 of our submissions. And it says this: first, what was said in Inchcup was obiter and therefore not binding. Second, what was said in Ferguson was obiter and there was not binding, and further that Ferguson simply refers to Inchcup, but without reasoning or explanation of any kind, as authority for the proposition that Section 1 was not binding, making no comment as to whether Inchcup was itself binding or as to the conflicting nature of the prior authority. So to answer your question, my Lord President, that is what we say about those two cases that you've raised. Then we go on to say.
Well, just a moment. I followed that, but I need to examine what you say.
Yes, of course. No, I understand.
Can we look at Inchcup, which is, I think, tab 12?
Yes.
Yes. Because this is the case about the Gaming Machines Act.
Yes.
And whether or not that infringed Mr. Inchcup's rights. And if one goes to paragraph 10, they cite Olivier. They say that Olivier was followed in Francis, Attorney General v. Great Bay, and then over the page, they refer at 13. Well, they refer to the reliance on a number of other decisions in the Commonwealth. And then at the end, paragraph 30, they say it's perhaps unfortunate that the outcome should depend on presence or absence of the word whereas. But but it seems that this is the basis of distinction adopted by the Privy Council. So they proceed upon the basis, as I understand it, following as they thought they were doing, the Privy Council, that Section 1 gave rise to a free and freestanding and enforceable right, which was the heading of paragraph 9 of what paragraphs 9 to 13 were dealing with. But they also found that Mr. Inchcup's business had always been illegal, so that even if Section 1 was independently enforceable, there had been no deprivation of property in breach of it. But that doesn't detract from the fact that they decided, item number 1, that section 1 was independently enforceable. And that would seem to me, at any rate, to be a matter of ratio. Or in the sense that you've used it in relation to the decision in Farias.
Yes, in that sense, perhaps the paragraph 12, the decision in Farias must be regarded as in curiam wrong, and yes, it is perhaps unfortunate that the outcome should have been that, but it seems this is the basis of distinction adopted by the Privy Council. Yes, in the sense that they do disagree with the, yes, I would
But I mean, this is of importance because
yes,
I understood your submissions to be that we were bound by the decision in Tobias. Because Fabius, I'm sorry, because it was ratio and the subsequent decisions of this court were not. And it appears to me, to take Inchcup at least, that there are 2 inconsistent ratio decisions of this court, which, as I understand it, tell me if I've misunderstood it, means that we are entitled and indeed bound to decide which one we prefer.
yes. Well, it is clear to me that Inchcup on this point was wrongly decided.
But, Sir Geoffrey, I mean, could you just respond to the President's point? Is it not the fact that we have the 2 inconsistent decisions on the basis of what the President's just referred to, and therefore we have to decide which we prefer?
I think that that would follow if they're yes.
Right.
And the same, thank you, the same, I think, applies in relation to Ferguson, because in which is at tab 33, in Ferguson, there were reliance on various specific provisions of the Constitution other than section 1. And if you go to paragraph 76, which is the very penultimate paragraph in Ferguson, the judge there, President Baker, says this: Mr. Pettingill, on behalf of Roderick Ferguson, submits that the DPA is void for additional reasons. He submits that his constitutional rights have also been breached under section 1A, protection of law, 9, freedom of expression, and 10, freedom of association. Section 1A is not an independent enforceable right, see Inchcup, and breach of the other sections was, as the Chief Justice said, virtually unarguable. So in Ferguson also, there was a decision which must be regarded as part of the ratio that section 1A is not an independent enforceable right.
Indeed.
Submitted that it was, and it was decided that it wasn't.
Yes.
Yeah, okay, thank you. So I think we're going to have to make up our minds, and we will no doubt, or hopefully, be assisted by whatever the Privy Council may have said on the topic.
Yes.
Which I distracted you from telling us. Right.
Right. I was going through the summary
Yes, I'm so sorry, I distracted you.
Paragraph 20. We also say that Inchcup on this point was wrongly decided,
Yeah.
as the court was bound to apply Farias and instead failed to do so. We say that Great Bay was wrongly decided also because the court was bound to apply Farias and did not do so. And therefore, the court was faced with precisely the issue, conflicting prior authorities, and could choose which one to follow. We totally accept that. But then we say that neither Great Bay nor Inchcup nor Ferguson could stand up with higher authorities, which is precisely the point that I was making for the new ground of Campbell, Rodriguez, and Neves as applied in Jamaicans for Justice, and an additional case that I will mention that is in the bundle as well, called Williams. And in the light of that, the court should and refuse to follow those cases. And this is precisely what we're saying. And we would also say that the result in Farias was consistent with those higher authorities and should be preferred. And it should also be preferred on the basis of the principled argument made for the direct enforceability of Section 1, which we've dealt with. So,
Right.
if I may then go to this case of Neves, I said I'd go straight to the Privy Council cases, but I think this is an important case with a respected Caribbean Court of Justice in Neves. I understand, and I may be wrong, that this case is on appeal at the moment, or has been argued before the Privy Council. So what we may see a change in this, but at the moment, this is what it said. And this was an absolute, complete, and utter direct enforcement of the Constitution of Barbados, which is set out in paragraph 24 and is very similar to the one we're looking at here. It's there, section 11, and it's in paragraph 24, and this, of course, is tab 15.
Sorry, paragraph 24 of what?
Of the case of Neves.
Where is that?
It is in tab 15.
Tab 15. Yeah,
Tab
thank you.
15.
It's page 11.
Yes.
Page 11 of tab 15.
Yeah.
Which sets out the provision in the Constitution of Barbados, which is in very similar terms to that of Bermuda. And the discussion begins on paragraph 25. The language of section 11 is not aspirational. Absolutely clear. Nor is it a preliminary statement of reasons which makes the passage of the constitutional sections of it desirable. The section is in two parts. The first part commences with the words whereas, the word which it is contended implies that the section is merely preambular and ends with the end of subparagraph D. This part gives effect to the statement in the preamble, which states that the people have had rights and privileges since 1652, and these have been enlarged since then. It declares the fundamental rights and freedoms of the individual to which every person in Barbados is entitled in clear and unambiguous terms. It is the only place in the Constitution that declares the rights to which every person is entitled. And then he goes on to discuss an article by Robinson and Balkan on the meaning of the word whereas, which would make section 11 impotent. I put it in the terms of a dead letter. And they pointed out that the origins of the judicial debate and on the preamble point are the cases of Olivier Malta and some other cases. And then they cite Lord Morris. And then in paragraph 27, they say, however, it must be noted that he accepted that the section must be given declaratory force independently. And he did not decide that it was only a preamble. He described it as being mainly in the nature of a preamble. And we accept that. However, in the cases where the preamble point has been utilized, his remarks are cited in support of the proposition that the use of the word whereas is an indication that the provision is merely preambular and not substantive. And then he refers to the case of the Societe United Docks, and then goes on in paragraph 30 to say, when one reviews the two sections in the Maltese and Mauritius constitutions, did they really intend to impute such different meanings as being attributed to them? And that is because the one case, because of the slightly different constructions of the Maltese and Mauritius constitutions, the Maltese constitution, like the Bermuda constitution, was held to be preambulatory, and Mauritius constitution not. It would seem to us that the Maltese constitution, the word whereas could easily have been construed to mean it is hereby recognized and declared that, or even simply in the light of the fact that. These are meanings normally attributed to the word whereas. We would think that the meaning of the word should at least reflect its context. In this case, the context would include the historical statement in the preamble to the Constitution of Barbados that the rights now declared were being enjoyed since 1652. The whereas should have been construed as intending to convey that simple fact. We can find no justification for attributing a meaning which deprived the section from any binding effects. And then he goes on to talk about the particular question of the content of a number of provisions in that section in respect to, in paragraph 32, protection of law, and then in paragraph 33 in respect of deprivation of property. And he says there in paragraph 33, citing Maya Leaders Alliance and the Attorney General of Belize, the notion of deprivation of property is often discussed in the context of the compulsory acquisition of property. It is evident that compulsory acquisition, which does not meet the conditions specified in section 17, undoubtedly amounts to arbitrary deprivation of property. However, there may be an arbitrary deprivation of property even where there is no compulsory acquisition. In other words, section 3 is not a mere preamble or introduction, but rather it is an enacting provision that recognizes and declares rights in property outside the boundaries contemplated by section 17. And then at paragraph, he cites the court at paragraph 41 and saying undue emphasis should not be placed on the location of the provision. It is the case the detailed provisions of part 2 of the Constitution must be construed in light of the provisions of section 3, but those provisions do not thereby curtail the ambit of the section. The wording of section 3 is not that of a mere preamble or introduction, but rather that of an enacting provision. And then the judge then says in paragraph 35, reviewing section 11 of the Constitution of Barbados, through the lens of this evolution, we can describe it as an enacting section. The reason which was applied to the provisions for the protection of law and unconstitutional deprivation of property, which pertains to this case, is equally applicable to the other subsections.
Yes.
And then I would ask you also simply to look at paragraphs 36 and 7. It is true that the extent of the rights declared in section 11A have not been tested in litigation in Barbados or in the Caribbean. But it could not be perceived that the rights declared in section 11A would be incapable of being defined or protected, except in the manner expressed in those following sections. One only has to look at the way in which the Indian Supreme Court has addressed the concept of life and personal liberty. There could be no justification for the courts in Barbados or the Caribbean to be prevented from considering whether the rights conferred in section 11A include protections not referenced in those subsequent sections. This principle would equally apply to subparagraph D, which deals very much with the important fundamental right relating to freedom of conscience and so on. In summary, section 11 declares the entitlement of the fundamental and inalienable rights of the citizen of Barbados. Section 12 to 23 afford protection to those rights and freedoms conferred by section 11, subject to such limitations of that protection as are contained in those provisions. My lords, I submit that case is on all fours with the kind of argument that we are seeking to make and had made earlier in the light of our analysis of this particular constitution.
So, Geoffrey, you indicated that you felt this case had been argued before the Privy Council. I mean,
No,
judgment was delivered almost 3.5 years ago. Do we know when it was argued?
No. Yes, I think it was last week.
Sorry,
My learned friend. Sorry.
I'm just to interrupt very quickly to answer your lordship's question. It wasn't argued before the Privy Council in a direct sense. The question of whether it is right or wrong is being decided by the Privy Council, or aspects of it are right or wrong, is being decided by the Privy Council in the case called Chandler, which is a mandatory death penalty case.
A different case. So
It's a different case,
I'm so
but
sorry.
they are looking to see whether the reasoning in Nove is reasoning that they would wish to be persuaded by, and thereby to overrule their own previous decisions on that
Right.
basis.
But this case has not gone to the Privy Council.
No, because the Caribbean Court of Justice is the apex court. It goes no further.
Right.
It goes no further there, absolutely. I'm so sorry, I do apologize. The issue there, an important issue in that Chandler case is the case of Nervez. I do apologize for that. And I'm very grateful to my learned friend for correcting me. My lord,
Chandler is a Trinidad and Tobago case, isn't it?
It is indeed, my lord.
Yeah, where the provisions of the Constitution are somewhat different.
They are
And
indeed.
It doesn't begin with whereas, and the
Correct.
redress section expressly includes the opening section.
All this is true. Yes, my lord.
Thank you.
My lord, may I ask you to look now at tab 16,
Yes.
Jamaicans for Justice. This is a case in the Privy Council where the appellant, a non-governmental organization, it's a case about, very far from this case, about reviewing of complaints of a senior policeman. The issue, and the issue there comes up, the constitutional question is the Constitution of Jamaica, which is set out in paragraph 125. The new Jamaican Charter of Fundamental Rights and Freedoms begins with whereas, and then continues. In paragraph 22, the issue of the independent enforcement of that provision is addressed, and Lady Hale says that in paragraph 22 on page 125, the Caribbean Court of Justice in Nervais and Severin, when construing section 11 of the Constitution of Barbados, which also begins with the word whereas, so she refers to Nervais at this point, held that this did not mean that the section was merely aspirational or a preliminary statement of reasons which make the passage of the Constitution or sections of it desirable. It was intended to have the force of law. The court went on to say of the right to the protection of law that it affords every person adequate safeguards against irrationality, unreasonableness, fundamental unfairness, or arbitrary exercise of power. So she begins there by citing Nervais and then continues in paragraph 23 and 4 to say, it is clear to this board that the PSC, like the JCF and Indicom and other organs of state, must exercise its functions in a manner which is compatible with the fundamental rights of all persons, including the right to life, the right to equality before the law, and the right to due process of the law. As Morrison put it, given that all organs of the state are specifically enjoined by the Constitution to take no action which abrogates, abridges, or infringes these rights, it must surely be equally uncontroversial to insist that all such organs are bound to respect and seek to protect the fundamental rights and freedoms guaranteed by the Constitution in all aspects of their activities. So she cites there Morrison J.A. saying that the rights that are in this provision, beginning with whereas and having to do with due process and so on, in particular due process, apply to all organs of the state, legislature therefore as well, which are specifically enjoined by the Constitution not to abrogate those rights. The board is also disposed to accept that the right to equality before the law affords every person protection against irrationally unreasonableness, fundamental unfairness, or the arbitrary exercise of power. These are in any event fundamental common law principles governing the exercise of public functions, as there is nothing in the statutory framework governing the PSC to contradict them. They are applicable in this case, irrespective of whether or not they have the status of constitutional rights. Now, those passages were sought by with the learned judge, Chief Justice, I submit, significantly misconstrued that statement. He advances a very narrow interpretation of her words in paragraph 75 of his judgment. In effect, contending that she was only dealing in those passages with judicial review of official action, in effect with administrative law, and not of review of legislation, simply because she, in setting out some of the criteria of equality for the law and due process of law, she mentioned some of the grounds of judicial review, such as we have already discussed: irrationality, unreasonableness, fundamental unfairness, arbitrary exercise of power. And with respect, this is not a correct interpretation of this at all. For a start, she starts off by citing the relevant passage in Nervais, which she seems to accept. Why otherwise would she cite it? She certainly doesn't disapprove or disagree with it in any way. It's before her, and she seems to take it forward in this judgment, practically speaking. This is her intention. And then she goes on to say, to cite Morrison J.A., saying that this applies to all the organs of the state. She's nowhere suggesting directly, or I would say indirectly, that only common law rights up to judicial review, administrative law, should be enforceable under that particular section. She's going far, far broader than that, and in fact deals with the due process of law guaranteed by the Constitution, doesn't in any way confine due process or indeed the right to equality before the law and the right to equal protection of the law in any way to judicial review cases. In my view, this is a fundamental misconstrual of Lady Hale's words. And in the end, she says, there is nothing in the statutory framework governing the PSC to contradict them. They are applicable in this case. They are applicable in this case, irrespective of whether or not they have the status of constitutional right. I would submit that what she's saying there is, it matters not whether they have a status of statutory right or constitutional right. In each case, they are applicable. That is what one has to construe with respect the notion of the word irrespective. Indeed, she possibly goes further than that by suggesting between the lines that there are some rights, such as equality before the law, that are perhaps constitutionally based on constitutional principle, in the way that a number of cases over which in which she has participated recently have decided that indeed the notions of due process, equality before the law, and the rule of law do apply as an inevitable consequence of living in a constitutional democratic society. So that is surely the background of Lady Hale's statement there. And I'll come to that further when we talk about particular when we discuss, when we look at particular rule of law issues. And let me say a little more about this in our skeleton submissions in paragraph 69.
So are you, it's slightly obscure what Lady Hale is saying. I think what you're saying is that what she is saying in 24 is that the board was disposed to accept that the right to equality before the law arises as a constitutional entitlement, and then goes on to say these are in any event fundamental common law principles. And as there's nothing in the statutory framework to contradict them, they're applicable in this case, irrespective of whether or not they have the status of a constitutional right.
Yes.
Yeah.
I think that's great, but there's a background there, which is that that of constitutional rights, which are sometimes in this country have been interpreted as, even without a written constitution seeking to constrain the government to abide by those rights, there's a notion that they inhere in the common law constitution in any event. In any event.
Just a minute, when you say they inhere in the common law constitution, I find that confusing. There isn't a common law constitution. They may be inherent in the common law.
Yes, under common law, what have been called common law constitutional principles, such as rule of law, and have been applied in a number of cases, in order to, where there's an ambiguity in the statute. I could deal with those cases perhaps later when we go in more detail into the rule of law. But the rule of law, for example, has been applied despite sovereignty of Parliament, when Parliament in this country is ambiguous, where a particular provision in the statute is ambiguous. The unwritten constitutional principles will fill the gap, such as access to justice. If the minister makes a regulation that seeks to increase court fees to a too high a level, making access to justice very difficult. The courts will apply this, and there is in both Miller cases, one of which is cited here, which is in our bundle. We could turn to that. Lady Hale said there, and this must be part of the context of what she's saying here too, and I'll turn to that later, if I may, that the protection of property is a constitutional, unwritten constitutional principle as well. So we'll come to that. But I think to cut this short, I think she's certainly not seeking to confine the statement here to judicial review of administrative action. She goes much further than that. She's endorsing a process of interpretation, a broad and rights-based interpretation of this particular provision. She's downgrading and ignoring the word whereas. She seems to accept entirely what was said in Nervais, and she quotes Morrison J.A. as particularly saying that this applies, particularly in a country with a written constitution, to all organs of state. So therefore, contrary to what was said by the Chief Justice, she's saying that it applies across the board to legislation as well as administrative action. And with respect, this has been misinterpreted.
So Geoffrey, can I ask you this question, please? And maybe it's a bit tangential, but I just need to understand. Assuming you're right and Section 1 declares people's rights, are you saying that under Section 15, which you rightly point out refers to any of the foregoing provisions of this chapter, a claimant or a plaintiff has a right to sue for protection from the deprivation of his property without the constraints set out in section 13?
Yes, that is our submission.
And you say that cut flows from the words of section 15, and the court doesn't need to be concerned with the clear constraints that are set out in section 13.
Yes, that is precisely what we're saying. Some of the clauses that are developed in relation to rights that are touched upon in section 1 broaden their ambit, others narrow their ambit by either in this respect by dealing with a particular aspect of property rights, but in terms of in terms of property rights, I beg your pardon, it is very clear that the additional section provides additional limitations on that right in terms of compulsory acquisition, particular issue of property law. But it would be surely anomalous if, having granted property rights, the Constitution intended not to allow constructive, what has been called in the cases which I'll turn to later, constructive acquisitions or constructive derogations of property rights. And we give some examples from paragraph 104 on in our submissions of that, where there could be constructive takings of property simply through regulation. And this is very common. We'll look at some cases on this in a moment. It would be anomalous if, having given a property right in section 1, you allowed only for property rights in terms of compulsory acquisition, takings, direct takings of property, and not of indirect takings, of what are called constructive takings, e.g. by interfering in a person's, by regulating to such an extent that they no longer have effective property rights, their use of property, as in this case.
Well, wait a moment. I understand you to say deprivation is not identical to compulsory taking of possession of property or of an interest in or right over property. You can have something which is deprivation but doesn't fall into taking possession or compulsorily acquiring an interest. Therefore, when section 15 says that somebody can complain of an infringement of his rights under the preceding provisions, that includes but is not limited to section 13, and it includes section 1, so that you can claim for deprivation, although it doesn't amount to a compulsory taking.
Yes, my lord.
I think we get slightly confused if we talk about constructive taking, because if there is a taking, whether actual or constructive, it does fall within section 13, so that the problem we have at the moment doesn't arise.
Well, I'm employing a term that's been used by Lord Wolfe in the one of the Mauritius cases that I will turn to later, where he just uses that term. It's the sort of issue that,
but he uses that term to cover what? To
cover the kind of instances that we set out in from paragraph 104 to 107 in our submissions. Maybe I could just turn to that for a moment. If this is what we say in paragraph 104, if section 1 is unenforceable and section 13 limited only to taking or acquiring in the literal sense of the word, meaning a transfer of title, the effect, therefore, is to permit deprivation of property without compensation, without limitation, in circumstances where deprivation does not amount to such taking or acquiring. by way of example, and then we give some examples to show this, it would be perfectly permissible for legislation to be passed allowing any member of the public unrestricted access to private property without the consent of the owner, and providing specifically that such access does not constitute trespass. So there's no particular direct taking there. This would have the effect of substantially depriving a person of the enjoyment of his property without the Bermuda government, or indeed anyone, acquiring or taking possession of the property.
I quite follow that. That's one of your two examples of that which can be deprivation, not amounting to taking possession.
Yes.
That, if I respectfully say so, has got nothing to do with constructive taking possession. It's an illustration that you can deprive somebody of property without taking possession of it.
Yes, I use the word constructive because it is a phrase that Lord Wolfe happened to use in that particular case, but I fully appreciate that perhaps what you're saying, with all respect, makes sense.
Right.
I take the point, but I still would submit that deprivation is not taking or acquiring in the literal sense, but it would be anomalous because it can have such a major effect on a person's possessions if it were not covered by a property right that we say is granted effectively in Section 1.
Right.
My Lord, there are two cases. I'll just refer first to the Williams case, which is tab 29.
Thank you.
A Privy Council case, which does deal with property. And deals with the Antigua and Barbuda Constitution.
Sorry, Professor Joel, could you give me the tab number again, please?
The tab number is 29.
Thank you.
And deals with Section 3A of the Constitution of Antigua and Barbuda. And I want to make simply one point about this case, and that is this, that Lord Sales interprets Section 3A of the Constitution which provides for the protection of the enjoyment of property and for the right to the protection of law, is separate from Section 9.1, paragraph 83, which explains this. Section 9.1 provides for protection against compulsory taking.
So where are we looking at?
I've taken you straight to, perhaps too much, with indecent haste, but I've taken you, my Lord, straight to paragraph 83.
Right, 83, thank you.
Yes. And here again, we have the earlier section of the Constitution, 3A3, providing for the enjoyment of property and a right to protection of law and to protection of property, whereas the subsequent section provides for protection against the state compulsory taking property. So the second section, very similar to the Bermudan Constitution. The later section provides for compulsory taking, proper taking, and the first section provides for a more general protection of the enjoyment of property. And simply, he then goes into an analysis of the issues without even referring to any kind of constraints due to the in the way that we have. In other words, it's totally ignored. The distinction, the equivalent of section 1 and the following sections are dealt with as if the old distinction, as if Lord Morris's judgment in Olivier had never been. This has to do with the lawfulness of freeze orders and those kinds of questions. The only point I make here is that it's a question of money laundering forfeiture regime, and the Privy Council is here analysing whether there have been any breaches of the protection of law right and the deprivation of property right on the basis of their rights, that those rights are enforceable. And he simply applies the test of proportionality in paragraphs 9 to 12. Sorry, it's proportionality, and it totally ignores any the kind of distinctions that have been made since the Olivier judgment.
Well, just a second. If you go back to, I see nobody seems to have referred to Olivier in this case.
No,
but if you go back to 83, what Lord Sales says is section 3A of the Constitution provides protection for the enjoyment of property and for a right to the protection of the law. Section 3C also refers to protection of property. Section 9(1) provides for protection against the state compulsorily taking property without payment of compensation, but is subject to qualifications in 9(4) set out above. The board considers that the nature of the combined regime in the LPA as a regime to govern property entitlements in the sphere of civil law, as analysed above, means that it is 9(4)(a), 2, and 4, which are the relevant qualifications in this context, respectively acquisition of any property by way of forfeiture in consequence of the breach of the law. So it is true that Lord Sales begins by reference to section 3A, but the operative provisions for this case were in fact the equivalent of section 13.
Yes.
Yeah.
Yes. The operative position in this case, in this context, he says, the relevant qualifications in this context, in the context of this particular case. But he by no means suggests that a property deprivation, the other sections are meaningless or dead letters, and doesn't join the issue in any way whatsoever. It's simply the point I'm making. He doesn't fuss about it. He simply applies the later section. And it may be that we can derive the implication from this that he regards both sections as operative, but the operative is the operative as potentially operative. But under the facts of this case, it's the later one that is relevant. And that's all I want to see.
No, thank you. I follow that. Thank you. Right. What's the next Privy Council case?
Yes. I'm so sorry. It was right here just a second ago.
It's either Lewis or Newbold, I suspect.
I was going to move to the Campbell Rodriguez, the Jamaican case.
Oh, yes.
That's a tab 14.
Mm-hmm.
Which I had literally a second ago and
Yes.
has vanished. Without Mr. Myers' presence, I'm severely handicapped, but there we are.
Volume 1 of your authorities, tab 14.
Tab 14. It's the case of Campbell Rodriguez and others in Attorney General. We're going back a bit now to 2007. The point I made earlier is that of late, the Privy Council seems to have pretty well abandoned the distinction that was raised in the Olivier case. But there is, I feel that I should really put this before you as well, because it is a case of some importance on this particular question. This is a case involving a road building project, road closures. And I bring it up now also because we've just been considering the difference between taking and deprivation of a property. And in this case, the claim was more for deprivation of property, in that a road had been closed and a tow road had been substituted, and the appellants claimed that their free and unrestricted access offended the peaceful and quiet enjoyment of their properties. And the issue is discussed from Lord Carswell's judgment starts by looking at chapter 2 of the Constitution of Jamaica, as it then was, introduced by, in section 13 on page 531 A to D. There it is set out once again, the whereas provision, and he makes then goes on to make a threefold distinction which we say, and this is a point I wanted to make, and it comes out of this case, explains a number of the why in some cases that appear to suggest that the Olivier the Olivier provision should still apply. The Olivier qualification, I should say, should still apply. The cases are very different. And on page 532, he says at letter E, at one end of the spectrum is that of Mauritius, which contains a general statement. He's talking now about the equivalent of section 1 of the Bermuda Constitution, a general statement declaring the existence of a number of rights, including that of protection from deprivation of property without compensation. That's deprivation. And then section 71 provides application for constitutional relief when any person alleges that any of those sections have been contravened in relation to him. And then at the other end of the spectrum, he says, is the Constitution of Dominica, which bears significant resemblance to that of Jamaica, which has the opening words are whereas, and then the rights and freedoms specifies are phrased differently, but include protection from deprivation of property without compensation. And he says there that the redress section, that is the equivalent of 15, is very different, because it may or may not give the right to apply for redress to any person who alleged a contravention of the provisions. So in other words, there are three kinds of constitution of provision. The one has here, sorry, if I may rephrase that. He makes the distinction between the whereas provision, it is hereby, or as in Mauritius, it is hereby recognized and declared that, which refers to a subsequent provisions, and then provides a redress provision, that's our section 15, some of which, but not all of which, enumerate specifics of aforesaid sections and say these are or are not applicable. And the point here is that the Bermuda redress provision, that's section 15, does not enumerate any specific sections. It simply refers back to the aforesaid provisions. In other words, it doesn't rule them out in any way, as some of the constitutions do, and that accounts for the difference in some of the applications in the different constitutions. But I wanted to look at this case because it also deals with, although it considers that in this particular case, he was going to follow the position of Great Bay. Paragraph 15 is important. It may be observed that there may be a taking, which is not, this is paragraph 15 in this case, which is not a direct physical appropriation of property or an ouster of possession. And then he talks about Lucas and South Carolina, nor does it appear necessary to show that there's been a transfer or change of ownership or possession from one person to another person. And that's the Belforce Corporation case. Some limitation of apparent breadth of legislative provisions prohibiting the taking of property without compensation must be implied. It is necessary to take care not to be over-analytical in examining the separate components of a phrase which requires construction. And the issue is to be determined by considering the application of the phrase as a whole. And then he says it may be of assistance to consider the first meaning of this context and consider the word taking. Mr. James, for the appellants, submitted that the word property should be given a wide or purposive construction and argued that the right to obtain access to one's property without economic burden constitutes a property right. Examination of this concept, however, reveals the existence of a number of difficulties. And then he says that every member of the public is entitled to a passage over the highway and so on. And then he goes on to consider the point that he's making there is that the right to property may or may not require direct physical appropriation and ouster of possession, but it may also It may not be necessary to show that there's been a transfer or change of ownership or possession from one person or body. And I'll return to this when we look at particular property considerations later.
But just a moment. If we go to paragraph 9, is it Lord Carswell? Yes.
Yes.
He sets out the different possible formulations.
Yes.
At various ends of the scale.
He puts Bermuda in the intermediate position.
Precisely. And then at paragraph 12, he says both the Constitutional Court and the Court of Appeal rejected the appellant's arguments that Section 13 conferred separate and independent rights.
Yes.
They regarded it as in essence a preamble and accepted the respondent's submission that its declaratory force was confined to declaring that the rights set out in Chapter 3 were not being created de novo, but existed prior to the Constitution. Their lordships are satisfied that Section 13 does not confer any freestanding rights, and that on the clear interpretation of the provisions of Chapter 3, the rights and freedoms enforceable under Section 25 are to be those set out in 14 to 24 inclusive. They agree with Justice of Appeal Cook when he said that a generous and purposive interpretation does not permit a distortion of the explicit relevant constitutional provisions.
Yes. Yes.
So that appears to be a decision of the Privy Council.
Yes.
Section 1 does not give rise to an independent right.
Yes. Sorry, my lord, I thought I made that clear when I said, I thought I said.
I'm sorry, perhaps I didn't pick it up, but
I don't think so.
Perhaps didn't say, I'm so sorry, perhaps I wasn't clear enough. But I thought it was right for me to go back to 2008 and not only take you perhaps to the reason that I want to deal with this case was first of all because it makes some pertinent observations on the question that had just been asked of me, because it makes the distinction between an actual taking of property and a deprivation of property in the way we've been describing. So it was partly an answer to that question that I turned to this case, perhaps a bit clumsily, for which I apologize. But what I intended to, but I did intend to say too that for the sake of completeness, I should say that up to this year, in 2008, 2007, the Privy Council sort of had not gone as far as certainly we would have thought they might have gone, and as we submit that they have now gone in terms of the cases, particularly of the Jamaicans for Justice case, where Lady Hale was quite, for me, quite clear that she accepted the judgment of Nervais. So that is what I meant to do. And I apologize for being a bit clumsy.
No, don't worry. But Lady Hale was considering the case in Jamaicans for Justice.
Yes.
Maybe it seems to refer to one case in another. The Privy Council in Jamaicans for Justice, see tab 16, page 119, was referred to a number of cases, none of which did not include Campbell Rodriguez. So there's a clear decision of the Privy Council in 2007 or 8. The same question arises under Jamaicans for Justice in 2019, and lo and behold, the Privy Council does not have it referred to them.
My lord, I might be able to assist a little bit to explain how these two cases relate to each other, if I may.
Yes.
In Campbell Rodriguez, the enforcement provision referred to a specific set of provisions which excluded the opening provisions. Campbell Rodriguez was the paradigm case, which in that case, they said, well, there's these three different categories of case. That case was, according to them, the paradigm case of unenforceability, because you would have to distort the language. Language which said 14 to 16 couldn't be read as saying 13 to 16, which one can understand. But that is not the position in Bermuda, where we have an open phrase foregoing provisions, as opposed to saying, for example, 2 to 17 or 2 to 14, we say foregoing provisions. In Campbell Rodriguez, that as the Jamaican Constitution stood at the time, they mentioned expressly certain provisions and they excluded expressly certain provisions, which included the opening provision. So the Privy Council says, well, you can't expect me to interpret the opening provision as enforceable when your enforcement provision expressly excludes it. But of course, that's not our case. In relation to Jamaicans for Justice, by that time, the Jamaican Constitution had undergone a sea change. It changed into the Charter of Rights changed in 2011 to become something very, very different. And it now does not look very much, actually, like, for example, Bermuda or any of the other countries. It looks like something quite different. The reason why Jamaicans for Justice is perhaps important here is because it has to do with the construction of the word whereas. Because what I think Lady Hale mentions, Nerve, there can be only one reason why she mentions Nerve, which is to give a stamp of whereas. And whereas had always been seen, for example, by the Court of Appeal of Bermuda in Inchcup as being the trump card, as being the thing that made it impossible to hold that Section 1 was enforceable. In Inchcup, they say, well, we've gone through all these cases, and it seems to be that whereas is the touchstone. Jamaicans for Justice says, no, whereas is no touchstone. Whereas doesn't allow you not to enforce Section 1. That's how these things all relate, I think.
Right. But
yes,
wait a moment. I am confused by this. Has the Jamaican Constitution changed?
It has.
So it said one thing at the time of Campbell Rodriguez and now says another.
It does.
I see. Well, the problem was that I looked up the Jamaican Constitution and assumed that it said in the time of Campbell Rodriguez what it says now, but it doesn't.
Interestingly, my lord, what's even more interesting is that at the time of Lewis, it said exactly the same thing as it said at the time of Campbell Rodriguez. And in Lewis, it was held that Section 13 was enforceable. Despite that, in Campbell Rodriguez, with no reference to Lewis whatsoever, the Privy Council then says something different. So yes, it's problematic all round, really, I guess is what I'm saying. It's not easy to trace through some kind of golden thread. But I think that if there is a thread, it is that if your enforcement provision expressly excludes your opening provision, then you count that your opening provision is enforceable. I think that's one rule that you can get from all the different authorities. We don't have that case. So that door is open for us.
Yes.
And because that door is open for us, we say.
Yeah, I think I follow.
Yes, we do.
It's very difficult if one doesn't have, because a lot may depend on the precise wording of the Constitution. It's
Correct.
very difficult to approach it without knowing what the precise wording is.
Yes.
Especially
yes.
if you look up the wording on the web, you find it wasn't the wording at the time in question.
I know the 2011 Charter of Rights was an effort by Jamaica to adopt what they said at the time was a progressive Charter of Rights that did things in a different sort of way. But the reason why I think Jamaicans for Justice is particularly helpful here is because Lady Hale didn't really need to introduce Nerve in relation to that particular version of the Jamaican Constitution. She introduced it, I think, to demonstrate that, or to put some sort of stamp of approval on Nerve's approach to the construction of the word whereas, which in the past had been held to disentitle a court from holding that the opening provisions were enforceable. And that's reflected in the case of Inchcup, whereas your lordship quoted earlier, the conclusion after their review was it seemed to turn on the presence or absence of the word whereas. But it no longer turns on the presence or absence of whereas, because Nerve says no, and because the Privy Council in Jamaicans for Justice approves that approach.
Yes, but by the time of Jamaicans for Justice,
Yeah.
the redress provision wasn't limited. It had been changed so that the redress provision was not limited to the sections that followed the equivalent of Section 1 in Bermuda. Is that right?
It had been changed even more than that, actually. There were redress provisions that referred to particular subparagraphs of their paragraph 1. I think the point is this, that what I will do, my lord, is I will get you a copy of what it looks like now. And I will provide the court with that so you can see exactly what it says. But I don't think that the question of enforceability arises in the same way in Jamaica now as it arose at the time of Campbell Rodriguez.
Well, because the redress section is different.
It is.
It's
very detailed.
Please get me the redress section at the time that it was for Campbell Rodriguez and the time that it is now, and tell me if it changed.
They have changed.
I know they've changed. What I asked you to do is to get me a copy of the
redress
redress
yes, of course, my
section.
lord. Yes, I will.
The two different redress sections, and to tell me, since I do not know, the time when they changed.
Okay.
Thanks
I shall do that.
Thank you.
Yes, my lord.
Right. So what's the next Privy Council case?
The Lord, the point, I'm grateful to my learned friend, I think that is where I would like to rest this particular case, that there have been developments, and particularly the point that Campbell Rodriguez makes is the one that you've just raised, absolutely rightly, that there are different constitutional provisions. The Bermudan provision has a whereas, but it also has a redress clause, which refers to the aforesaid provisions and without any limitation. Many of the other constitutions provide that particular sections aforesaid may not be directly implemented. No such thing is said in the Bermudan case. So we would, I think, like to rest this on the basis of the reading that we gave to this, the interpretation that we put on this.
Well, I don't think it's as easy. I don't think it's as easy as that, because there are two Privy Council cases to which you refer. One is Lewis, and the other is Newbold. In so far as I can see, neither of which was Jamaicans for Justice cited, which appear to me to say diametrically opposite things. Shall we look at Newbold?
Yes, where are we? Newbold
Tab 28.
Yes, my lord.
This is 2014. If we look at the cases referred to in the judgment,
yes,
they include Campbell Rodriguez.
But not Jamaicans for Justice, because that was subsequently decided.
Oh, was it? I'm sorry. Yes. Oh, right. Yes. Okay. Right. That's fine.
And sort of while we're with Newbold, my lord,
Yes.
may I just refer you to paragraph 33 of the judgment?
Yes.
That reads, in short, Mr. Fitzgerald's submission does not only run counter to the natural meaning of Article 15. He says it ignores the word whereas.
Sorry, where are we looking at? Where are we
I'm looking at paragraph
Paragraph
33 of the judgment in
Twen-
Newbold.
23,
33.
33.
Yes.
Yes.
It says, in short, Mr. Fitzgerald's submission does not only run counter to the natural meaning of Article 15, it also ignores and Article 15 is their opening provision.
Yes.
It ignores the word whereas, which we've dealt with, and the recital in Article 15 that it is the subsequent provisions of this chapter that shall have effect. Finally, it ignores the clear implication of the restriction of the right of redress under Article 28 and the restriction of the saving of existing laws from challenge to cases of alleged contravention of Articles 16 to 27. If Article 15 had been understood as an independent enacting provision, the constitutional right of redress would have been extended to it. So this is a case where under the Bahamian Constitution, the redress provision expressly excluded the opening provisions.
Right.
And indeed, it was worse than that. There was an existing law savings clause, which also expressly excluded the opening provisions. So essentially what the Privy Council is saying here is that in circumstances where, one, your enforcement provisions don't expressly exclude a particular provision, firstly, and secondly, your existing law savings clause, the purpose of which is to save laws that were existing at the time of the Constitution from constitutional attack, when that clause doesn't include a particular or refer to a particular clause, the inference is that it was thought that that clause was not enforceable, and so it did not need to be added to those clauses which would be immune from constitutional attack.
Well, that's
but we don't have those factors.
Just a moment. That's one of the grounds for decision.
It is.
But if you go back to paragraph 33,
yes,
Lord Mance says Mr. Fitzgerald's submissions does not only run counter to the natural meaning of Article 15, it also ignores the words whereas and the recital in Article 15 that it is the subsequent provisions of this chapter which shall have effect for the purpose of affording protection of the aforesaid rights. So the first two, let me finish before saying it. The first basis upon which Lord Mance decides is that Article 15, which is I think the equivalent of Article 1 in Bermuda, the idea that gives independent rights is inconsistent with its natural meaning and ignores the words whereas, to which he obviously gives some importance. And then finally, it ignores the clear implication of the restriction of the right of redress. So there are three different bases, three different factors upon which the Privy Council reaches that decision.
That is true, my lord. But what we would say to that is that in relation to the reference to the word whereas, that kind of reasoning has been overtaken by the endorsement of the Privy Council in Jamaicans for Justice of the Nervée approach to the interpretation of that word.
I see.
So we would argue or submit that Nervée and Jamaicans for Justice removes that first pillar.
Yes. Just a moment. Well, you say that it's been overtaken by Nervée, which is not a Privy Council decision.
That is true, my lord.
Right. And Jamaicans for Justice, which is a Privy Council decision.
Yes, my lord.
Let me just, not terribly helpful, these authorities are not in chronological order. Jamaicans for Justice is at 16. And lo and behold, Newbold was not cited. Okay.
Now I myself have become lost with these binders.
Yes, well, I agree, and not surprising.
Sorry.
Newbold
That's
is
correct.
tab,
Newbold was not cited. Correct.
not no. Right. So are we bound by any of this lot?
I think that what I was. I'm sorry. Go ahead.
Carry on.
Well, I repeat my question. Are we bound by any of this lot? And if so, which?
Yeah. Go ahead. So
Well,
Jeffrey.
I have my firm view is that I started off by saying it was a tangle, and I think it still is, and I think it would be useful to untangle what you can, and on a basis of principle, and I think it is open for you to do so, and common sense. And to rid everyone of this strange obsession with the word whereas, which we would submit is completely misplaced, for that's that kind of word to drive the case law of so many countries for so long. And it's so long ago that this happened. And in recent years, this has no longer been happening. And in recent years also, the kind of anomalies that would leave high and dry people who look at a constitution and think there's a right there to deprivation of property. Constitutions are there for the ordinary person in the street and not merely for lawyers. And they see themselves having a property right or a right to protection of law or whatever it might be. And then they're told by courts that because there's a word there that might obstruct it, they are no longer, they may no longer have those rights. I think it is time, with all due respect, to bring back the original Farai's case as the authority of a great judge as well there with George's, and a local judge, and I think that this is a very, and I think we have the Neve case may not be direct authority upon you, but it is, I would say, highly persuasive. It is an apex court in the region, and this is important.
So, Jeffrey, if I could interrupt, please. I'm not fixated on the word whereas at all. I'm much more fixated on the main clause: the subsequent provisions of this chapter shall have effect for the purpose of affording protection to the aforesaid rights and freedoms, subject to such limitations, etc. And I think I mean, I take what you say about whereas, fine, those are the rights, but it's the limitation that seems to me to be implied in the subsequent, or in the main sentence of section 1 that I am fixated on.
Let me say why I think the fixation need not, it should be dissolved. If I may say. And it is this, that we now know that we know this from the various human rights instruments, particularly, let's say, the European Convention on Human Rights. We know that there are a number of rights that are very few rights are absolute. Nowadays, it's just about one, possibly two, namely torture, life. Even life is often qualified. So they all need to be those rights all need to be tailored. And I think this is a recognition. This constitution was written when well into the life of the ECHR and the UN equivalents. All of those rights had tailored limitation clauses. So you may depart from, you may justify this right and get out of applying it in the interests of public policy, public order, public health, and so on. And so I think all that section was doing was saying, here they are, and the way they're adumbrated, developed later on, is because we have to tailor them more specifically. We're proclaiming them here. And in subsequent, for some of them, not all of them, we'll either somewhat not tailor all the rights, such as property, leave deprivation here, but don't want to talk about compulsory acquisition, because that's the language of the ECHR and of the other international human rights instruments. So we're giving a direction here: go forward and tailor them for limitation in the later sections. But these are what are fundamental.
And my lady, may I just add something very mundane, which may assist?
Yes, please do, Mr. Myers.
It is the wording of section 15.
Well, that's your get out of jail card, isn't it? You've got.
I think so, because
Yeah.
because I mean that more than balances subsequent provisions that says foregoing. And of course, section 1 is a foregoing provision.
Okay, what about this, Mr. Myers?
Yes.
Under that section, the court can make such provisions as it thinks appropriate, make such orders as it may consider appropriate. Why should this court consider it appropriate to make an order in relation to property deprivation, which is not subject to the constraints set out in section 13?
Because, my lady, I wanted to explain it at the time, there are in fact constraints that are set out in section 1. And this is explained in the Mauritian cases, which I'll go to in a minute. What those cases say, because in Mauritius, their version of section 1 has been enforced for the longest while, they've worked out how to make this, how everything fits. And what they've said is that you have wider versions of the rights in section 1, but you also have wider versions of limitations. So in section 1, it says, subject to respect for the rights and freedoms of others, and subject to the public interest. In other sections, particular categories of public interest are identified, so that the exception or the constraint, it is not that section 1 doesn't provide for any constraints. It says that whatever you get out of this section has to be measured against the public interest and the rights and freedoms of others. So it is, in fact, it's a broader right, but also a broader constraint. In fact, obviously, the Privy Council puts it a lot better than I do. In the case of La Compagnie Sucrière, which is at tab 23, if I might just take you there. And if one looks to page 501 at letter E, tab 23, page 501 at letter E.
Just give us a moment, Mr. Myers.
Certainly.
501.
Yes, indeed. At letter E, small e.
Yep.
Do you have it, my lady?
Yes, I've got it.
Good.
It's the last pile. I'm in the last pile. Okay, I've
I'm
got
so
it.
sorry. So their section 3 is our section 1. The correct approach is therefore to read section 3C and section 8 together with the relevant language of each section influencing the interpretation of the other. Section 3C, however, remains at the same time both the more general and the more qualified provision. More general, as its protection applies to a wider range of situations and a broader concept of property than does Section 8. More qualified, because the protection it provides is restricted by broader limitations than that to which the protection provided by Section 8 is subject. Even when generously construed, Section 8 is limited to protecting property and property interest from interference, which in a broad sense involves some formal compulsory taking of possession or acquisition of property, or of what loosely corresponds to a right over property. The property or interest in property must be sufficiently identifiable to be capable of being taken possession of or acquired in this way. However, once property to which Section 8 applies is compulsorily taken or acquired, then the section is contravened unless all the requirements of Section 8(1)(a), (b), and (c) are fulfilled, or one of the other limited exceptions in Section 8 applies. The qualification on the protection provided by Section 3 is in much more general terms. There is therefore a significant distinction between the protection provided by Section 3 and Section 8, notwithstanding their close relationship. So that's the classic passage that is cited to explain what the relationship between the a version of Section 1 and a version of Section 13.
Well, that's okay so far as it goes, but take the following set of circumstances. Assume that there is a taking of property that falls within what in the Bermudan Constitution is Section 13. Assume that.
Yes.
So you could claim under Section 13. However, Section 13 is subject to some restrictions in its application.
Yes.
Could you also claim under Section 1 that the compulsory acquisition of property amounted, as it were, a fortiori, to a deprivation of property, and therefore you could claim under Section 1 without having to comply or to fall within the conditions specified in Section 13?
I think the answer to that question, my lord, is found in the last sentence of the passage that I just read. That there is a significant distinction between the protection provided by the one and the protection provided by the other. What I think that implies is that if you fall squarely within one, you are not going to be allowed to argue the other.
Mr. Myers, can I just take you back to the definition of 3C, which is, the provisions of 3C set out Section 499. And when one compares them with the provisions of Section 1, looking at
what page are you on? What page are you on?
499.
Thank you.
I see, yes.
And where it says, and the provisions of this chapter shall have effect for the purpose of affording protection to those rights. So it leaves out
subsequent. I'm sorry, my lord, you're saying it leaves out the word subsequent. Sound is gone.
Yes, no, we hear you now.
No, your sound had gone, my lord. I didn't hear that last part. I'm sorry.
Right. So when I read the provision of 3C, shall have effect for the purpose of affording protection to those rights and freedoms. So that is looking at the full provisions of this chapter, whereas the word subsequent has been excluded.
It doesn't occur, yes.
Now, that suggests a rather material difference between the two provisions.
It does, but then one goes back to the wording of Section 15, which is foregoing provisions, as I think I was just discussing with my lady. I think, as my lady puts it, it's a get out of jail free card. It's not quite free, but I think that you can say that if you have something that is balanced, that could go either way in relation to the interpretation of the Constitution, you should perhaps take the route that is rights affirming rather than rights denying, because that, to my mind, is sort of fairly tried constitutional interpretation principles. If you have a choice, choose rights.
Thank you. That's helpful. Thank you.
Thank you, my lady.
Sorry, coming back to your answer to my question beforehand, which is if you come within section 9 and section 1,
Yes.
can you rely on section 1 in order not to have to comply with the conditions in section 9? You said the answer is to be found in the last sentence of the second full paragraph at 501, which reads, there is therefore a significant distinction between the protection provided by section 3C and section 8, notwithstanding their close relationship. That appears to me to raise the problem rather than provide the answer. You appear to be saying that the answer is, if you come within section 1, you can't bring yourself within section 13. But unfortunately, as a matter of linguistics, it's perfectly possible to fall within both. A compulsory acquisition of property deprives you of it.
Ask to be allowed to answer that question more fully
Of course.
later on today.
Yes, all
I have
right.
to think about that a little bit more.
Yeah, okay. You may need time to produce an answer.
Thank you, my lord.
Right. Right. Where do we go next?
Right. Thank you. We would like to now move to consider whether there has been a property deprivation in this particular case. And if so, to what extent and why?
Yes.
And if I may, this is best considered by looking at the progressive, we would say, smothering of the autonomy of the corporation, particularly since 2010, which is set out usefully in the judgment at page 1201, paragraph 27.
Yes.
Starting with the Municipalities Reform Act of 2010, which abolished the business ratepayer vote. There were two kinds of votes, residents and business ratepayers. This was taken away. The Act also repealed, in the next page, paragraph 28, the collection of wharfage. The Municipality Amendment Act of 2013 restored the business ratepayer vote. It was a change of regime and included a number of described as good governance provisions, one of which required the submission of all corporation ordinances in draft to the responsible minister and the Attorney General for review, so that they could able to amend or repeal any ordinance. That's on page, further on page 1203 at D, and also doing much else besides. It's all set out there. Then there was a Municipalities Act of 2015, which provided the minister with greater supervision, including the right to attend and receive minutes of the corporation. It also provided on the top of page 18, no resolution of the corporation should have effect until approved by the minister. It permitted the minister to give general or specific directions to the corporation if the minister considered it in the public interest and was consulted. And it allowed the minister at that point temporarily, and it's got worse since then, to assume control of the corporation's financial governance if he thought they were in a poor state in the public interest or being mismanaged. In 2018, the Amendment Act provided in relation to the minister's power, on paragraph 35 now, minister may give mandatory and binding directions which shall be deemed to be for municipal purposes and a function of the corporation. This is an extraordinary provision. And we'll look at it again in respect of rule of law. What it does is to gives the minister power to make binding directions on the corporation. And whatever they are, they shall be deemed to be for municipal purposes and a function of the corporation, even if they're not. They shall be deemed to be. This is quite an extraordinary, draconian, almost an exclusionary clause that allows the minister to define the jurisdiction of municipal purpose, and however he defines it, it shall be deemed to be a purpose and function of the corporation. And also the power then to take over the corporation under the stewardship provisions, no longer on a necessarily restricted temporary basis. So the minister can just walk in and take over. Now, you may think that this is a kind of almost a neutering, as it was put in much evidence, and particularly the evidence of the mayor, Mr. Gosling, which I've come to, of the corporation. But the proposed Reform Act then goes even further by proposing that municipal elections are abolished and replaced by selection and appointment of members, again centrally. And the existing councillors are required to retire, and the mayor and 4 councillors are to be appointed by the minister acting in his discretion, and the remaining 4 councillors are again to be appointed by the minister acting on the recommendation of the selection committee. And the members of the selection committee are again appointed by the minister. Now, this is all set out in a very neutral way in the judgment. And in paragraph 38, he says that the corporation contends that this level of control amounts to unlawful deprivation of property, contrary to sections 1 and 13 of the Constitution. The Attorney General contends that the objective of the proposed Reform Act is to create a governance system for the corporation whereby the many challenges of the provision of public service in Bermuda may be dealt with in an orderly way upon establishing a more closely cooperative relationship with the central government. We submit that the effects of the Amendment Act culminating in the 2019 bill is to place the corporation and its assets entirely under the control of government. We regard this as at least a deprivation of their property. And at most a taking. The government has said that it wants to align the policies of the local authority, coordinate them, regulate them. And the judge has accepted this is a form of regulation. The terms that are used in the evidence by the mayor and others are, this is a strangulation, a control, or a land grab. So this is what has happened. The minister or his representative is entitled to participate in all the corporation's deliberations in relation to any matter, and these are set out in all these acts. The corporation cannot make a decision without a resolution, and simply a resolution, and the resolution then requires the minister's approval in writing. The corporation cannot even approve a budget, far less expenditure or borrowing, without the minister's participation and approval. In relation to the disposition of land, even after the minister has participated in the deliberations, and even after an approved resolution, the corporation must submit a draft of any agreement to sell or lease it for a period of more than 21 years to the Minister for Cabinet's approval, and then the approval of the legislature must be obtained, and there's nothing that prevents the Cabinet from refusing resolution for disposition of land. So that's a deprivation. Again, in relation to land, the corporation...
Where are you now, Sir Geoffrey? Are you still in the Chief Justice's judgment?
I'm sorry. I was simply I was trying to describe some of the effects of this on the. I've moved from the Chief Justice's judgment. I'm sorry. I'm trying to summarize the kind of controls that the various acts.
That is the consequence of the Reform Act.
The consequence of all the acts, plus the Reform Act, and that is the consequence. And this is also set out in Annex 3 of our submissions, which contain the initial submissions on pages 4 to 8, which simply go through all the Annex 3 in our skeleton, attached to our skeleton submissions, and which contains some submissions that were made to the court below. And from paragraph 8 on there, you will see the various restrictions that are imposed upon the corporation by these various statutes, and the reduction of its, effectively, of its autonomy.
Can you tell me where these are in the bundle?
They're in the bundle with the appellant's submissions, and with annex, is this correct? This is annex number 3. Is that right?
Which is tab 3.
Tab 3. And if you would, I was summarizing this, but it's all contained in much detail there. It's, if you look at page 4.
I'm sorry. I'm sorry. Just wait a minute. Because these documents are so voluminous, I have separately printed out your submissions, but I have not separately printed out the annexes to the submissions, and I'm having difficulty in finding where I find the annexes to the submissions.
Perhaps Mr. Myers could help us with that.
I think they were attached to the submissions, my lord, on the website.
I see.
You know, there was a SharePoint website.
Yes, I know. So we haven't got any hard copies of them. No.
No, because the court said that it would print them for you.
Well, perhaps I've got them somewhere.
I have them in hard copy.
Right. Well, okay, don't worry. I'll find them. Yes.
Right, so if I could just go back one step and summarize it. If we go to paragraph 8 of that document, it talks about the first bullet point, talks about the minister participating in all the corporation's activities, the resolution procedures, and then it comes to the various, on the first 2 bullet points on page 5 of that document. It looks at the fact that the corporation effectively must submit a draft of any land agreement exceeding 21 years to the minister.
I'm sorry, Sir Geoffrey. We're no longer in Annex 3, I take it.
I thought we were.
Well,
I've now fixed 3, which somebody had printed for me.
my Annex 3, if I get to page 5, it's
Not what you said.
correct.
Oh.
Annex 3 has got a discussion of Olivia.
It's actually, if I can say that paragraph 8 of Annex 2.
Annex 2.
Oh, is it Annex 2?
Yes, that's my fault.
I'm sorry.
Okay.
Paragraph 8 of the submission at Annex 2.
I'm so sorry.
But that is entirely my fault. I
Right.
misled Sir Geoffrey.
Don't worry.
Thank you.
Yes.
So you were on page 5, Sir Geoffrey, in Annex 2.
Yes, indeed. The first bullet point relates to the disposition of land, which I've mentioned. And then the next bullet point talks about, again, in relation to land, the corporation may carry out development works, where the works are calculated, facilitate, or conducive or incidental to the discharge of any function of the corporation. And the footnotes here cite the various sections of the 1923 Act that now incorporates the amended acts. The minister may issue mandatory directions to do anything, any act or thing, and once having given such a direction, as I said, the act or thing is deemed to be for a municipal purpose and deemed to be a function of the corporation. Again, I mentioned that earlier, you see it now in more detail. It's quite extraordinary. And there's nothing in the statute, we read here, to prevent the minister from directing the corporation to carry out works on its land, which benefit the government or any member of the government and not the corporation. And such works could be deemed to be for municipal purpose and a lawful function of the corporation. We say that this is this violates the rule of law profoundly. And indeed, we say too that there is nothing in the statute to prevent the corporation from transferring its lands or work to the government or any third party, provided that the minister considers it in the best interests of Bermuda, which we say here is an elastic concept, to say the least, and provided there's some degree of prior consultation, which of course may be ultimately ignored because the minister's power is expressed in absolute terms. The next bullet point goes to say that all the corporation's powers, functions, or activities are qualified by the minister's overarching, virtually absolute power to approve or disapprove of it or its exercise of continuous initially. And then, having decided whether to approve or disapprove the resolutions, to issue any direction to the corporation to do whatever he wishes in relation to it. For example, it goes on to say, although there may be other controls as well, for example, the charging of rates requires an ordinance under the statute, and ordinances are controlled by the government, even as to their form. Yet, having been through the necessary process to enact an ordinance, the corporation could simply be directed not to implement it. So it gives pretty well absolute power over this local authority. And then it goes on to say at the top of page 6, despite the government's layers of control, if, for example, the minister believes there's been mismanagement, which given such control, it can only be assumed would have been required equal participation of the government, the minister has power to assume the whole control entirely of the corporation, including its financial governance and overall governance, for an indefinite and undefined period, which comes to an end only when the minister is satisfied that such control is no longer necessary. And that's important to note because some of the cases about deprivation of property involve the actual, control of the management of the company on a sustained basis. And finally, this document says that the bill leaves all these controls in place, but removes any pretense that the corporation has any existence independent of the government by doing away with elections. And we say this is quite extraordinary too. Doing away with the elections that have been going on for 300 years and providing for the appointment in the way that was mentioned by the Chief Justice through selection effectively by the minister. And he will then control the majority and the casting votes. And he has power also to remove persons appointed if unwilling to carry out their functions, which it should be remembered he may determine by directions. So it ends by saying, if the bill is enacted, therefore, the government will not only control the corporation's functions, powers, activities, finances, governance, it will also be in a position to appoint persons to the corporation who are thought to be likely to support the government's agenda, whatever that may be. And this is why the corporation effectively is going to become part of the government.
Jeffrey, I think that I wonder whether that might be a convenient moment to adjourn.
Yes.
Before we do so, can I just float some considerations with you? It seems to me that it could be said that what the government has or is proposing to do in relation to the corporation falls into distinct categories. The first, in no particular order, is that the minister can give effectively directions to the corporation to do anything, which, unless there is some restriction on that, would appear to entitle the minister to order the transfer of the corporation's land to itself or to somebody else, either for a full sum or for no sum at all, or for something in between. I can see that could be said to be a compulsory taking of possession or a compulsory acquisition of a right or interest in land. That's category number one. Category number two is if the minister or the legislature decide not to approve a decision of the corporation, such as a decision to sell land or to sell a lease or to create a lease in excess of 21 years, and don't propose to offer any compensation. I have some difficulty in thinking that that is a taking possession of property or the acquisition of a right in property, but it could be said to be depriving the corporation of the property because it removes from the corporation the ability to dispose of it. That's category number 2. Category number 3 is changing the composition of the corporation so that it's no longer elected by ratepayers or ratepayers and residents, but is in effect selected directly or indirectly by the government. As things presently stand, I have difficulty in seeing how that constitutes a deprivation of property or a taking of possession of property or a compulsory acquisition of a right in property, because as I understand it, the property that the corporation owns will remain with the corporation, though those who constitute the corporation will change. So there seem to me to be 3 different, there may be more, but there seem to me 3 different categories in relation to which different considerations may apply. Now, I may have got that wrong, but I thought it might be helpful to let you know.
I'm very grateful to that, Lord. I think I personally find that helpful. I also, the third question, in some ways, that I would say the removal of the elections is the most egregious, or between that and the deemed powers, is most egregious of all. And I sought to place attention on that by saying that this is seems to us to be a invasion of free political speech, political expression. Right. But that's the matter which we may return to. It might be a slightly different issue. Right. But certainly I could say that both 1 and 2 could both potentially be deprivation. That's a very helpful category to come back to.
Okay, well, is it convenient to everybody if we were to retire for, say, 45 minutes?
My Lord, before we retire, there is a short point I would like to take.
Yes, Mr. Knight.
And my Lord, thank you. It's in relation to the rule of law point. And I think it has a reasonable ending, but I have to go through a short explanation to get to the ending point. And I'd be assisted if the court had a copy of the skeleton argument that we provided, entitled Skeleton Argument Submissions of the Respondents in relation to the summons dated the 7th of October.
Yes.
I can take you straight to paragraph 14 of that document.
Yes.
The appellants now seek to rely on a new point of law, protection of law under section 1A, with respect to one provision in the legislation. Lord, you'll see that if you look at their skeleton argument at paragraph 111, footnote 50.
Yes.
So at paragraph 111, footnote 50, you will see that that paragraph is contained under the rubric of a ground of appeal above paragraph 108, entitled Contravention of the Right to Protection of the Law and the Rule of Law under section 1A of the Constitution, and inherently under the rule of law. And the offending provision is section 7AA in brackets 1A of the Municipalities Act 1923. Our position is that that argument was not made in the Supreme Court. It's not contained in the notice of appeal. And turning over to paragraph 15 of the skeleton argument I asked you to look at, it's important to note that at first instance, the way the argument was framed was that protection of law was argued in the context of a breach of the Constitution with respect to the lack of consultation.
Yes.
They argued this point on the basis of a lack of consultation. At first instance, they lost on that point, since which that point was abandoned.
Yeah.
They now seek to challenge one specific provision in the Amendment Act for the first time on appeal.
Yes.
And they're arguing that the provision is contrary to the rule of law under Section 1. So it's all rolled up in this separate enforceability of Section 1. This is Section 1A. And it's unclear exactly how and under what parameters they are making this argument, particularly in light of the relief sought. I'm not seeking to make my argument now. I'm just explaining why we will need to make some submissions with the leave of the court. It's unclear as to whether or not the striking down or the declarations that they originally sought in their originating summons under, and it's to be noted, under a Section 15 challenge is what they are seeking to do now. And this court is going to have to grapple with what is meant by inherently under the rule of law. Is it separate and distinct from the Constitution? Certainly, it isn't a point that was canvassed in the original hearing, in the notice of appeal, or even in the supplemental notice or the summons. Now, whether the court wants to view this as a point that it will take de bene esse, I'm not seeking to suggest that they can't argue the point because they're in the middle of arguing it now. All I'd like leave from the court to do is to file a brief response to that one point so that we can have our submissions before the court, because certainly when we read their skeleton argument, we didn't fully understand the point until we got their letter of the 7th of October. So, 21st of October, the summons is the 7th of October. So it's not attempting to stop my learned friends from relying on the point. The court's already indicated that it's going to deal with the points as they come. We would just like to be in a position to at least give our response. We've heard some of the sweeping statements that have been made, and there are some quite cogent responses to them.
Didn't you do that, Mr. Duncan, with your letter of 22nd of October?
My Lord, no, our letter of the 22nd of October was responding primarily to the application for leave on the freedom of expression point, and we didn't get an opportunity to file submissions. What we were doing, which the court has decided not to entertain today, is we were saying they shouldn't have a right to argue the point, but if they did, then obviously we would seek leave to file submissions. We only filed brief submissions in our skeleton argument of 17th of September. But with respect to this point, we would just like to put some points before the court that were not put before the learned Chief Justice because this point wasn't argued before him.
Well, I dare say that Sir Geoffrey won't object to some brief further written submissions.
Not at all. And I'm grateful for that submission. My position certainly was that I had assumed that protection of the law had certainly been argued below, applied in a particular context to due process, but it's not a far cry from there to expand it into something slightly different. This particular point wasn't concentrated on, but it was very much within the realm of the discussion. And of course, in respect of rule of law inhering in any constitution, even in the United Kingdom constitution, without, as I discussed this earlier, without a written constitution, which has been held frequently, and I cite the cases where it has been held in this section, Privacy International, Anasminic, and so on, that the rule of law ought to prevail.
Let's argue about this. Let's argue about this later.
Yes.
I must give notice that I do not understand the point. You say in paragraph 100, and don't give me an answer to this, but let me just tell you what I don't understand. You say it is clearly a contravention of the rule of the law for a body, which I assume means the corporation, with inevitably limited powers, themselves, i.e. the corporation, to possess the power to define the scope of those powers. I don't follow how the corporation is given the power to define the scope of its powers. So you'll have to explain to me how that works.
Oh.
Right, well, shall we take a 45-minute break?
It's 1 o'clock Bermuda time, 5 o'clock UK.
Yes, thank you.
Thank you.
The parties who are remaining in the chat here, could you please turn off your cameras and mics?
Oh, sorry.
Thank you.
Mm.
What's going on about whereas?
Everyone here?
Yes.
Yeah. Okay.
Where is, oh, there he is. Okay.
I think,
Just a
where's
second.
Mark?
Let me unmute the president.
So, Jeffrey, I'm afraid before you start on your further submissions, there's a matter on which I would like your help, because it seems to me another decision of the Privy Council, which is, to me at any rate, a little confusing. If you go to tab 35, we get the decision of the Privy Council in the case of Lewis and others against the Attorney General, a Jamaican provision. And if you go to paragraph 281, which is part of the recitation of the facts by Lord Slynn, he records at the top of 281 that in its then form, the Constitution of Jamaica provided by Section 25 that a person who alleges that any of the provisions of sections 14 to 24 inclusive of this Constitution has been or is being or is likely to be contravened in relation to him may apply to the Supreme Court, which may make such orders and give such directions as it may consider appropriate for the purposes of enforcing or securing the enforcement of any of the provisions of the said sections 12 to 24.
Okay.
So as we've seen before, they were dealing with a constitution which provided in its redress clause that you could obtain redress, but expressly did not refer to section 13 of the Constitution, the equivalent of section 1 in Bermuda. However, if you go back to page 277, one finds in the headnote, item 2, that by reason of the accession of Jamaica to, sorry?
I'm sorry, go ahead, my lord. I didn't mean to
Please
interrupt.
don't interrupt.
I'm sorry.
By reason of the accession of Jamaica to international conventions and of the fact of allowing individual petitions to international human rights bodies, I leave out the brackets, the appellants on petitioning the Privy Council of Jamaica for mercy were entitled to the protection of the law in accordance with section 13 of the Constitution. So this is a case in which, despite the fact that the redress provisions did not cover the first section, the Privy Council held that the appellants were entitled to the protection of the law in accordance with section 13. And if you look at how they did it, one finds that at page 303. If you go to actually the bottom of page 302, Lord Slynn says it is of course well established that a ratified but unincorporated treaty although it creates obligations for the state under international law, does not in the ordinary way create rights for individuals enforceable in domestic courts. This was the principle applied in Fisher, but even assuming that applies to international treaties dealing with human rights, that's not the end of the matter. Their lordships agree with the Court of Appeal in Lewis that the protection of the law covers the same ground as an entitlement to due process. Such protection is recognized in Jamaica by section 13 of the Constitution and is to be found in the common law. Their lordships do not consider that its right to distinguish between a constitution which doesn't have a reference to due process, but does have a reference to the protection of the law. They therefore consider that what is said in Thomas and Baptiste is to be applied mutatis mutandis to the constitution like one of Jamaica, which provides for the protection of the law. In their lordships' view, when Jamaica acceded to the American Convention and allowed individual petitions, the petitioner became entitled under the protection of the law provision in section 13 to complete the human rights petition procedure. So they appear to have proceeded on the basis that although the Constitution expressly provided that section 13 was not included in the redress section, the appellants were entitled to the protection of the law provision in section 13, which they say is recognized by section 13 and is to be found in the common law. What's not clear to me is whether they were in fact saying that the appellants were entitled to the protection specified in section 13 because that section was to be found in the common law. And in any event, they appear to have reached a decision which is the opposite of the decision which we were looking at a moment ago, where the judgment was given by Lord Mance.
Campbell Rodriguez, yes.
Yes.
Yeah, absolutely. I think this analysis is absolutely correct. And if you look at
so which analysis is absolutely
your
correct?
Analysis, your in the sense of to the extent that you say that it is contrary to other decisions and does allow direct independent application of the section. We deal with this in the following paragraphs of our skeleton submissions, if I may.
Yes.
54,
Yes.
74 to 76, 54, 74 to 76, 78 and 79. And what we say in summary is that Inchcut cannot stand with Lewis. We also say that Newbold, in order to explain Lewis, did comment that it was limited to protection of law and did not mean the opening provisions were enforced generally. But we also say that Lewis enables the rule of law to become a constitutionally justiciable principle through the protection of law right. So yes, on that respect, this was of course a death penalty case involving the question whether it was contrary to the protection of law enshrined in the opening provisions, but to execute the sentence of death in circumstances where the convicted men had not been shown the material which the decision of the Jamaican Privy Council for mercy, on which they dismissed their petitions, and they weren't allowed to make personal representations. So it is a kind of due process case. And there were two international human rights commissions that had recommended this. And it was held in this case that protection of law was enforceable and was the equivalent of due process. And they invoked the rule of law referring to Thomas and Baptiste, as you say. It's an extraordinary case because the judgment was also delivered shortly after the Privy Council judgment in Great Bay, in which the Privy Council did not make any critical remarks about the Court of Appeal's holding there, that the opening provisions were unforceable. It just sort of accepted it, didn't criticize them. Yet here, the Privy Council had no hesitation in holding the exact opposite. And of course, as you say, the Jamaican Constitution also opens with provisions, the whereas provisions, and the use of the word subsequent provisions, and whose redress provisions expressly omit any mention of the opening provisions. In other words, totally similar to the Bermuda provision. So I might have been remiss in confining my use of Privy Council decisions to post-2015 or thereabouts to show a change of mood, because there are cases earlier than that, and this is one of them, and I gratefully accept your referring to.
Well, just before you extend your gratitude further, can we look at paragraph 79 of your submissions?
Yes.
Where you're dealing with the judgment of the Chief Justice. You say he deals with Newbold, but with respect misunderstands the point. The point of Newbold, as was explained in the submissions below, was that in order to explain Lewis, which clearly held that Section 13 provided an enforceable right, in that particular case to protection of the law, Lord Mance was driven to comment that the case should be understood as only applying to that particular right. That is what is being done at paragraph 32 of the judgment. But if we can go to back to Newbold, which is at tab 28, where do you say that Lord Mance was driven to comment that Newbold could only be understood as applying to the particular right of protection of the law?
Right. This is a challenge.
So, my lord, can I take that question?
Yes, please.
Yes.
I recall this.
I think in order to understand the what's being said in Newbold, you have to go back to paragraph 28.
Yes.
And there, the story of enforceability is sort of related. He says that in these circumstances, i.e., where the opening provision says whereas and says subsequent, and where the enforcement provision excludes the opening provision, he says in those circumstances, it's no surprise the Jamaican courts, up to and including the board, have rejected the argument that the Jamaican equivalent of Article 15 conferred separate and independent or freestanding rights that could be relied upon for redress, etc. Yeah. Then he goes back to Olivier. Then he says, but Mr. Fitzgerald relied upon Thomas and Baptiste, an appeal from Trinidad and Tobago, Lewis and the Attorney General, and the Attorney General against Joseph as indicating a different conclusion. He then deals with those cases, and he says all three were cases, and this is in paragraph 29, all three were cases where the death penalty had been passed and the person sentenced had petitioned the Inter-American Commission on Human Rights under the American Convention on Human Rights, excuse me, which the respective countries had ratified at the international level. The Constitution of Trinidad and Tobago was in very different form to that of the Bahamas. The provision invoked in Thomas and Baptiste was on any view and enacting provision, section 4.
Right, well that solves the problem in relation to Thomas, because...
Right, then the next one he deals with is Lewis.
Yes.
At paragraph 30, he deals with Lewis. He says in Lewis, the circumstances were similar, although not the provisions, but the circumstances were. The appellants contended that they should not be executed until the Inter-American Commission and UN Human Rights Committee had reviewed and reported on their petitions. As already observed, the Jamaican Constitution is, however, in the same form as the Bahamian, rather than that of Trinidad and Tobago. Nonetheless, the board, without commenting on this difference, treated the protection of the law to which Article 13 of the Jamaican Constitution, Article 15 of the Bahamian, refers as equivalent to the due process of law referred to in the Constitution of Trinidad and Tobago. Lord Hoffman dissenting, it thus applied the reasoning of Thomas against Baptiste to reach a conclusion that execution should be stayed. So there he's saying that in Lewis, despite the provisions of the Jamaican Constitution, they still managed to find, without commenting on the difference in the provisions, still managed to find that the protection of law was an enforceable right. In the same way that the court had found it enforceable in Thomas and Baptiste. And then he refers to Attorney General against Joseph, which is the CCJ case at 31. Same story. It was also concerned with the Constitution of Barbados, materially identical form. That reference is elucidated and so on. I'm sorry, I'm just reading quickly. The court thought that around the middle of that paragraph.
Where are you, Mr. Myers?
I'm sorry, I'm on paragraph 31 of the case of Newbold at tab 28.
Right.
So he says he then refers, having dealt in 30 with Lewis, he then goes to deal with Attorney General against Joseph. Bear in mind, these are the cases that were put forward by Mr. Fitzgerald to contradict the conclusion that the opening provisions were unenforceable. So at 31, he's dealing with Joseph, which is a Caribbean Court of Justice case. And he says that was also concerned with the Constitution in materially identical form to Jamaica and the Bahamas, which means that the redress provision excluded the opening provisions. He then says in paragraph 58 onwards, the court accepted that section 11 of the Barbados Constitution, the equivalent of Article 15 of the Bahamian Constitution, which he was dealing with, was basically a preamble, save it concluded in relation to the reference to protection of the law. That reference was elucidated only in section 18, which on its face dealt only with aspects of the trial process. The court thought that the protection of the law referred to in section 11 would be a very poor thing indeed if it were limited to cases in which there had been a contravention of the provisions of section 18, the specific provisions. It did not agree with the Privy Council's conclusion in Thomas and Baptiste and Lewis that the ratification of the American Convention could make the individual right to petition part of the domestic criminal justice system, but it considered that by ratifying the convention, the state had created a legitimate expectation that the death sentence would not be carried out while a petition to the international body was on foot, and that this should be enforced by a stay of execution. So he deals with Thomas and Baptiste in one way, in 29. He then deals with Lewis at 30. And he accepts that in Lewis, what happened was that the Privy Council, without commenting on the differences in the provisions of the Constitution, they still went ahead and held that protection of law in their version of Section 1 was enforceable. And then he deals with Joseph, and he says in Joseph, the reasoning was that the specific provisions relating to protection of law were so narrow that you had to think that it must mean something more than that. Then he says in 32, the board does not consider that these three authorities assist the appellants in the present case. They are emphatically not authority for any proposition that Article 15 of the Bahamian Constitution operates as and provides a general source of protection of human rights overlapping with the substance of all the rights provided by the subsequent specific articles. They address a completely different subject matter to the present, and at best support the view that the concept of protection of the law can extend to matters outside the scope of Article 18, posing there that must mean that protection of the law in their version of Section 1 is broader than protection of the law in their version of Section 6, which is the fair trial right. He says it supports the view that protection of the law is broader than that. So it's enforceable to the extent or in relation to the concept of protection of law and no further. He's trying to explain how the Privy Council came to the conclusion in Lewis that protection of the law, which is in their section 1, could be enforceable at all.
Well, it's remarkably opaque. He cites
true.
three. He cites. I mean, it's require the interpretive skills of the oracle at Delphi to understand this. He cites 3 cases,
Yes.
each of which holds that there is no independent right in the first section, each of them being cases where the redress provision excluded the first section. He then says the board does not consider that these 3 authorities assist the appellants in the present case. But I'm so sorry. He cites the first 2 authorities were ones in which it was held that there was no independent. Oh, wait a minute, was it? I've got lost now. In Lewis, it was held there was an independent right. In Attorney General v. Joseph, it appears to have been held that there was an independent right, at any rate in relation to protection of the law. He then says the board does not consider that these 3 authorities assist the appellants in the present case. Well, that's slightly curious, since 2 of them hold that there was a right, an independent right. And then he says that they address a completely different subject matter to the present, and at best they support the view that the concept of protection of the law can extend to matters outside the scope of Article 18. Well, how does that help one? Be it assumed that the concept of protection of the law extends to matters outside the scope of Article 18, that's the fair trial provision. That begs the question as to whether or not the concept of protection of the law gives rise to an independent entitlement under the Constitution. Doesn't seem to grapple with that at all.
And my lord, that is why I use the word driven, because it is a bit opaque.
Yes,
I think that Mr. Fitzgerald, having cited Thomas and Baptiste and Joseph, and particularly Lewis, it became difficult, and Lord Mance was trying to find a way around it, to be honest, because it's very hard to see how Lewis is not authority for the proposition
Yes,
that
right.
Section 1 is independently enforceable. It's very hard.
I see what you say, but you courteously say that Lord Mance was driven to comment that the case should be understood as only applying to that particular right.
Yeah.
If that's what he meant, it wasn't clear to me from what he was saying that is how he was saying the case should be understood. But you say that's the only way, charitably, to
make sense of it, really.
Yeah, I follow. Thank you.
Thank you, my lord.
Thank you, my lord.
Right, I'm sorry for that distraction.
No, that was very, very helpful. My lord, there were 2 issues that were left over the break.
Yes.
One was the query raised by Mr. Duncan in respect of the point that we are seeking to make in respect of the deemed powers. And I fully accept that we haven't, that our paragraph 111 of our submissions doesn't quite make the point that it should. The point that it should make is this: can a minister, through executive power, expand the powers of a body with limited powers and which it controls.
Well, no, he can't, but that's not what's happened. What has happened is that the legislature, with legislative powers, has altered the composition of the authority and its powers. And that's something the legislature can do.
But can the legislature introduce a provision assuming a constitution that upholds one of the most fundamental aspects of the rule of law, which is that when the legislature confers powers on a body, the body must keep within those powers intra vires. If the legislature seeks to create a situation where the executive can violate that fundamental law by simply declaring powers as he wishes by fiat to be deemed powers, irrespective of the legislation already there, isn't that legislation contrary to the rule of law in a country with a written constitution?
But the deeming is done by the legislature. Such direction shall be deemed to be for municipal purposes and a function of the corporation. I mean, the legislature is the creator of the corporation. It can add to, subtract from, or change its functions.
Yes, I see.
I don't see why it can't say that in relation to anything that the minister directs the corporation to do, A, it should be bound to do it, and B, it shall be a function of the corporation to do so. Because what in effect the legislature is saying is, henceforth, one of the functions of the corporation shall be to do whatever the minister tells it to do. And although the minister couldn't do that sort of thing, I don't follow why a legislature can't.
Well, is there not an intermediate position? Because the minister, the legislature has already laid down powers with limits in respect of corporations. Let us say that the legislature provides that a corporation can do the following: set rates, keep up the parks, and let's say not build bridges. That's for the central government. And then the legislature passes another act without amending the first act in any respect, and simply says the minister by his fiat can expand those powers. So if the minister says local authority go out and build bridges, that is now deemed to be a power within the Municipalities Act.
But that's not the minister extending those powers. The corporation extends those powers by saying that not the corporation, the government, the legislature extends those powers by saying that the power and function of the corporation is to do what it's instructed to do by the minister.
My Lord, perhaps in a country without a written constitution and without the notion of protection of law, and perhaps in, if I may say, in a despotic country.
But wait a minute, you've got the protection of law. That which the legislature does, it does by passing laws.
But look, there are many decided cases, including the leading case of Anna's Minnick, where Lord Upjohn says very clearly that discretionary powers can never be infinite. They always must keep within the terms and powers of the body concerned. They must always be intra vires.
Yes.
And it's I think it's very difficult to. I mean, in some ways, this is almost worse than an ouster clause. Ouster clause says you can do what you wish, but you can't be judicially reviewed. This says you can only do certain things. And we haven't changed that. But now we're giving the power to the minister to expand your powers, corporation, which you can't do. You have no power to do what the minister tells you to do. So there's a subsequent act that says, no, the minister can tell you to do anything outside of your powers.
Yeah, sorry, get around in circles. If the Act says you must do anything which the minister tells you to do, the Act says that, it becomes one of the powers and functions of the corporation to do that. In Annie's Minnick, the question was whether or not you could exclude consideration as to whether somebody had properly used powers, whether the Investigatory Powers Tribunal had properly addressed its mind at the relevant question. That's a different point, completely different set of circumstances.
With respect, in Privacy International, the question is whether the provision by the legislature that the investigatory powers was judicial review proof could stand up if it was accused of acting outside of its jurisdiction. In this case, in what is sought to be done here is, as I say, even more despotic. It is saying simply that although you have limited, we don't deny that you have limited powers, but this is a question of substance. You, the minister, have power effectively to do whatever you like to unlock those powers, to allow the corporation to build bridges, where even though it has no power at all to build bridges.
Well, wait a minute, how is it, I mean, let's get down to brass tacks. How is this going to work in practice? Under the relevant legislation, the minister can tell the corporation what to do. Let us assume that he tells them to do something. And it said, you can't do that. It's not part of our functions. How do you tell whether what he tells them to do is part of their function, given that they're bound to do what he tells them?
Well, I mean, if any of us were advising the corporation, you would seek a judicial review, and this court would have to decide whether the minister has a power.
Right.
Now,
so the court would have to decide whether the minister has a power. And since the legislature has specifically given the minister the power, it's going to be rather a short case, isn't it?
No, not if we say that the practice that the government in a democracy is not unlimited, and these powers defy the rule of law simply by giving the minister the power to order illegality, unlawfulness. Can the minister, this I perhaps phrases it, what I'm trying to say at the back, you're providing power here for the minister to require the corporation to act unlawfully.
No. That would introduce a completely new set of circumstances. If the legislature orders says that the minister can tell the corporation what to do and the corporation must do it, that couldn't possibly extend to the minister can tell the corporation to commit a crime and they must commit it.
Well, not a crime, but to go outside of its powers. But under this system, if the minister says, go out and build bridges, which would be unlawful under the Municipality Act, they cannot do that. It's never been contemplated that they would do that. The minister is in effect saying, you must go out, I'm ordering you to go outside your powers. And what I now do, it's true that the legislature says, now these are your deemed powers. Well, this is the stuff of despotism.
Right.
And basically that's the point we seek to make. It's constitutionally, if I may say, totally irregular. And that's all we say. I mean, I could develop the point de bene esse, or now, but I certainly feel, and we would argue that this is constitutionally outrageous and has never, I don't think, ever been seen anywhere.
Would the legislature be entitled to pass an act which says the Corporation of Hamilton may do anything?
I think that is better than this, what it is now proposing, because it is then, we all know, and the public know, that the corporation is unbounded, that it can tackle any job whatsoever, central, and it can send ambassadors to the COPS conference.
Sorry, the corporation is unbounded.
If you're saying it can do whatever it likes, it makes it, the
No, I see.
legislature makes it unbounded.
If the legislature says that, yeah. Oh.
Yes, I agree. But for the legislature to say the minister can order the corporation to do anything it likes outside of its confined powers.
But that, sorry, when you say outside of its confined powers, that assumes that the powers are confined. But if the statute says your powers are to do anything, they cease to be confined.
Yes, well, indeed. Well, I would agree. I think if the legislature says you can do anything, the corporation, then the corporation can do anything.
Well, if the legislature can say the corporation can do anything, presumably it can say the corporation must do anything which the minister requires it to do.
Well, if I may say, this is no, because the corporation is already bounded. It is bounded by the Municipality Acts. Those give it certain defined powers. If we now say the minister may extend the corporation's powers without amending the corporation's powers through the legislature, then I think it is questionable. Certainly it's questionable on the grounds of rule of law, because this becomes government by fiat. So certainly fails on that ground. Whether it still has the power, I would think, maybe in the United Kingdom, but see the ouster clause cases, where the rule of law tends to prevail. But certainly in a country that enshrines the protection of law, and legislation cannot go beyond that constitutionally, my answer is no.
Right. Okay.
So, my Lord, just to finish that point, then, I mean, we've somewhat taken it, and were I to develop it, I would look a little more carefully into the notion of the rule of law and how and the analogy with ouster clauses. But perhaps I could return to the property deprivation issue now. The categories that you have provided, we find are exact and helpful, except that we feel that there may be an intermediate category. And that is if the actual control of the corporation shifts to the government. If the government can control the corporation, it can therefore control their assets. And there are cases on this, which I would want to look at briefly, because there are cases where the management of companies was taken over from the existing management. And the question is, were they really deprived of their property? I can presage that by saying that in each case, the court believed that it was certainly possible for a deprivation to come about in that way, by putting in people to sit at the board and sit at the management's desk, but held in each case that the control, and the operative word there is control, was perhaps not sufficient, not sufficiently permanent. So the case, in each case, it was held that there was no deprivation, but they certainly came pretty close to that. So the cases we could look at there are Lawrence, first of all, tab 47, and then proceeding to Panton, which is tab 48, and then Paponet, which is tab 49.
Right.
And there was also the case that I put up this morning, Campbell Rodriguez, which also deals to some extent with that issue.
Right.
Attorney General Lawrence is at tab 47. And as the head note shows, Edmund Lawrence was the managing director and chairman of the board of directors of the National Bank. And the House of Assembly passed a bill, and on the afternoon of that same day, 6 members of the police force entered the head office of the bank and purported to hold meetings there. And then they purported to remove him as director of the bank and terminate his service. So this is where this is going. It's going to the kind of control that the minister will exercise over the corporation in this kind of case. And if you look at the head note, point 2, property rights in which are protected by the Constitution, section 6, should be given a wide and liberal construction to include not only concrete rights of property, but also abstract rights such as rights of management of a company. The case, what happened in this case in the end is the result of that is provided on page 930 of the case at letter B. I am of the view that section 6 applies equally to concrete as well as abstract rights of property. And I would hold that management is an important incident of holding property. Accordingly, I would accept that the learned trial judge was right in concluding that such deprivations as Lawrence had alleged and shown fell within the purview of section 6 of the Constitution. So this raises the question of the kind of control that's going to be exercised. The legislation in this case permits the minister to exercise. If I may now turn to Panton in the next tab 48, the following. Lord, a strong case in the Privy Council. If we could look at the head note again, the appellants were shareholders in 3 financial institutions. Following investigations into the activities of one of the institutions, the Minister of Finance and Planning assumed temporary management of the 3 institutions. Temporary management. Now, in this case, you'll recall that initially the legislation allowed the minister to take temporary management of the corporation, and then later the subsequent legislation allows the minister to sit there pretty well permanently until such time as he decides that he's no longer needed there. And the question was, is this a taking of the property? But it was held, if one just needs to look at point 3 on page 134 of the head note to see what happened there. The appellants had to show, in order to establish their claim of deprivation of property, the appellants had to show that the action of the minister constituted a taking of their property. However, what the minister did was to take over control of the company. The appellants remained shareholders, and none of their property, including their shares, had been taken away. Equally, no one had been dismissed, and thus no one had property taken in the sense that they were removed from office. Ultimately, the statutory provisions were regulatory rather than confiscatory, and therefore no obligation to compensate arose. This has to do with compensation, and this judgment there by Lord Clyde, which says that, which goes to paragraph. Yes, but that repeats in what I've just read from the head note is repeated on page 143 in paragraph 22. The appellants were they remained there, and they remained shareholders. So there wasn't no real. It couldn't be said that there was a taking or a deprivation in that case. And then we have the next case, which is the following tab, tab 49, Papanet. Again, here we see the facts from the head note. The applicants were members of an association who owned and operated maxi taxis, public service vehicles, and so on. They controlled and managed their own affairs and did not pay for the use of their taxi stand, which was located on a public road. And then progressively, the government moved the taxi stand to a new location, into the premises of their competitor, which they eventually agreed to do in reliance on government assurances. So this case is largely about legitimate expectations. However, the government then introduced regulations and require the taxi company to apply for a permit, and the members of the association were required to pay a fee of $1. There's a judgment by Lord Dyson with a dissent from Lord Brown, which deals at page 10 with the, sorry, at page, it starts off in paragraph 19 on page 9 in dealing with the authorities that the Court of Appeal had dealt with, including Campbell Rodriguez, which we saw earlier, where it was held that there was no taking of possession of the property. And then it carries on to the to say that on page 23 that in order to improve an infringement of the right to enjoyment of property, assuming that it is possible to do this, it is not necessary to show in a business context that the infringement makes the operation of the business impossible. But it must reach a certain level of significance. And in many of these cases, the principle was applied was that was not that a regulatory restriction could not of itself involve the taking of property. In other words, a regulatory restriction could involve the taking of a property, but as Lord Hoffman put it in Great Bay, it is well restricted that settled that restrictions on the use of property imposed do not constitute a deprivation for which compensation should be paid. And at paragraph 25, it was not necessary for the that dealt with the Trattoria case. I'm coming to the central parts of this case. Good. In effect, it was said, I'm sorry, I just lost the paragraph where Lord Dyson says that the interference must be substantial to amount to deprivation. In order, I'm sorry, I beg your pardon. Paragraph 23. In order to prove an infringement, there is not necessary to show business and consummation operation of that business impossible. Here it is. Sorry, I know I marked this up, but for some reason, there is no marking on that particular page, which I thought I had marked.
That might be because I've got two versions of the same report.
Oh.
So you might have two.
This is my summary of the case is very clear in my mind. Lord Dyson for the board made clear that in a case where there was no direct expropriation and where the appellants were subject to the management of their competitor, as in this case, in other words, where there was a loss of control rather than expropriation of assets or possession, and where that loss of control was alleged to interfere with property rights, the matter was a question of degree, and a contravention would require the control to be substantial, which it was held to be in that case. And what we say in this case, so it's a matter of what Lord Wolfe in another case, which I should show your lordships, La Compagnie Sucrière, the Compagnie Sucrière, at tab 23. This was the case where I referred to Lord Wolfe's use of the word, he actually uses the word constructive deprivation. This is 23. He also, Lord Wolfe also says, and I'll come to that in a minute, that whether there's a deprivation is simply a matter of fact and degree. And I'll come to Lord Wolfe saying that. What we would submit strongly is that the kind of control that is exercised, envisaged to be exercised, and is possible to be exercised over the corporation as a result of this legislation, that kind of control, as a matter of fact and degree, is such that it actually, for the reasons that I've already adumbrated and read up, the control over the, and under the categories that my Lord President raised just before lunch, plus the additional one we would say of significant control over the corporation, leads us to believe that in this particular case, the control is such that it certainly amounts to a deprivation of property and the right to deal with property. So turning now to La Compagnie Sucrière, a very different situation, but simply lays down the approach to adopt in this kind of case, along with the European Court of Human Rights' case of Sparong and Sweden, which comes up here, and in a number of these cases. This is a case about again, Mauritius, the appellant sugarcane planters who leased land under the historic land tenure system of métayage in return for rent based on the share of the price. And the law was changed so that planters' freedom to contract in respect of their right to leased land had become somewhat fettered, and they claimed that there was a deprivation of property there without compensation. And it was held, and I look at the footnote, the headnote on page 495. The increased, in the middle, end of D, just before letter E, the increased control of land which section 5A involved did not contravene the sections 3 protection by the lack of any provision for compensation. Since a fair balance between the interests of the community and the rights of the individuals whose property interests were adversely affected had been achieved, which was a question of fact and degree for the court, which would be allowed a substantial margin of appreciation. So that's his approach in this case. On the other hand, it's very clear in the case and in all these cases that it is possible that the interference with full ownership rights of one kind or another can constitute that kind of deprivation. And so applying that to the category which my Lord President submitted just before the break, we would agree that under category 1, the minister can give directions to the corporation to do anything which would appear to entitle the minister to order transfer to the corporation's land, even to himself. And under those circumstances, we say that it certainly permits that kind of compulsory taking, and that would be a compulsory taking. Category 2, where the minister or legislature decides not to approve a decision of the corporation, such as a decision to sell land, and doesn't offer compensation, that may not be a taking or an acquisition of a right in property, but it certainly could be said to be a depriving the corporation of property because it removes the ability to dispose of the property. And we think that is absolutely correct. On the ground of, on the election, this actually removes the voice of the voters and dismisses the existing councillors. This perhaps is not in the realm of property. We say it is very much in the realm of political speech and offends in all sorts of other ways a democratic situation, even though the technically even if one believes that the legislature can do absolutely anything it wishes to do, it is inhibited. I won't get into the argument about, at this stage, the argument about expression. And then we say that there's an intermediate category which it shifts control to the control, all about control. And those are the various cases, Peppernet in particular, and Panton Lawrence deal with this. If the government can control the corporation, it can control their assets. And the answer to that really is Lawrence and Peppernet. That is our submission on that.
What category does that come under? Deprivation?
Yes, it's we discussed that over the break between ourselves and also Mr. Myers, and we thought it was simply an intermediate category or an extra category.
Well, wait a moment. That won't do. I don't understand that. I mean, in order to be a breach of the Constitution, it has to come within the constitutional provisions, and that makes questions of which constitutional provisions. But it either constitutes a deprivation of property, or a taking of possession of property, or an acquisition of a right or interest.
Yeah.
Which would you like it to be?
I understand. We would say, may we discuss this among ourselves?
Yeah.
Yes.
May I respond?
Yes.
I think that in light of cases such as Campbell-Rodrigues, which recognizes that if regulation goes too far, it can amount to an acquisition, I think that our first position would be to say that if you have regulatory control that goes too far, then that amounts to an acquisition. That would be our first position. Our second position would be to say that even if it doesn't amount to an acquisition, it certainly is at the very least a deprivation. That's the way that I think we would put it.
Yes. Well, I think maybe we're talking here about, there is I mean, we called it intermediate because we're thinking of the notion of fact and degree, where there's a sliding scale. And I would accept entirely what my learned friend has just said. If it goes too far in terms of control, then it's an acquisition. If it goes less far, it can be a deprivation, or it may not qualify for either. But it is a question, it has to be a question of fact and degree. And we feel that what is happening here is very high on the scale.
Sorry to interrupt, but we have a situation, my lord, where the minister could say, I direct you to hand over your property to me. That would then be deemed to be a function of the corporation and be deemed to be lawful. The fact that the legislation is attempting to deem that kind of thing to be lawful is the problem. That's the problem with the deeming provision. But in essence, it's saying that the minister can give a directive to do anything. Anything includes hand over your property. And then he does that, and the corporation says, hold on a second, you can't do that. And then he says, yes, I can, because it's deemed to be a function of the corporation. So it's fine.
No, it wouldn't work like that. That would requiring the council to do what the minister requires would mean that if the minister requires a handover of the property, the council, it's within the functions of the council to do so. But that begs the question as to whether having to do so in the circumstances without any money in return is an expropriation of the property. If my property is expropriated, I have power to hand it over to whoever expropriates it. I am the owner. I can transfer the property. What makes it offensive is the fact that I have been required to transfer it without any money in return.
Indeed, which is that. But so I think we are agreeing with each other, my lord. Excuse me, I'm losing my voice.
Broadly speaking, yes. Right. Yes.
So those are our submissions on that issue. Lords, the subsection 13.3 contains a...
Just before we get to 13.3, let's just assume that you're right about this. As we stand, as I understand it, the minister hasn't required the council to transfer any property, or told it that it can't transfer any property.
Yes.
So we're not dealing with a concrete set of circumstances, so that any what the court, if you're right, what the court would have to do would in effect be a declaration that the what has happened is inconsistent or contravenes the Constitution insofar as it permits the minister to do X, Y, and Z.
Yes, yes. We're seeking a declaration, not
yes.
kind of,
I just give notice in advance that nobody has actually drafted a declaration, and it may be more easier said than done.
We accept the challenge.
Yes.
All right. Subsection 3. Yeah.
Three. This contains a qualification as follows: nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of subsection 1 of this section, to the extent that the law in question makes provision in the public interest of any property or the compulsory acquisition in the public interest in the right over property, where the property interest or right is held by a body corporate established by law for public purposes, in which no monies have been invested other than monies provided from public funds. And in paragraph 121 of the judgment, the Chief Justice said that since he had held there was no contravention under section 13.1 of the Constitution, it was unnecessary to consider whether section 13.3 disapplied the section. But he did express views from paragraph 121, concluding in paragraph 127 that the purpose of section 13.3 is limited. It's limited to the operation of laws which expressly allow for compulsory acquisition of property, such as under the Acquisition of Land Act. And he held that the amendment in proposed reform did not provide expressly or impliedly for the compulsory taking of possession in the public interest of any property. And we would agree with him that section 13.3 is confined to the operation of laws which expressly allow compulsory acquisition of property. That is, to be taken, to permit takings in the public interest under any statute that would be like the Acquisition of Land Act, I would imagine. It had to be very, as I recall, in a previous case, in Bermuda, it's very carefully constructed with procedures for consultation and challenge and so on, and compensation. So the carefully drawn provision of the Acquisition of Land Act there are a case in point. But we disagree, however, with the Chief Justice that section 13.3 is intended to apply to implied acquisitions of property, specifically to the kind of what we would call acquisition by stealth that really characterizes the present case. If you look over the years, particularly from 2010, one by one these statutes have been coming in, and each of them, I think, takes another bite at the assets of the corporation, culminating in the actual extinguishment even of its free elections and its voice. But we would say
where did the judge say that there's you say that you disagree with him when he said that it didn't apply to implied acquisitions?
I said that he discusses this from paragraph 127.
Yes.
And
I may have got lost in the negatives, but I thought you said you disagree with the judge insofar as he said that the exception doesn't apply to implied acquisition.
Implied acquisitions.
I can't see where he says that.
Yes, it's on 127. However, it seems to me that the purpose of section 13.3 is limited to the operation of laws which expressly allow for compulsory acquisition of property, and to provide that such an acquisition does not amount to a deprivation of property of section 13.1. I think that's what we read.
Don't follow. Sorry, what? I can't understand what you're not agreeing to.
But what we're saying is that the purpose of 13 is limited to operation of laws which expressly allow.
Yeah, well, you agree with that. You agree with that.
We agree with that.
You appeared to be saying that you didn't agree with the judge when he found that the exception didn't apply to implied acquisition.
Yes, yes.
And he doesn't say that.
No.
So there's nothing.
My Lord, when I said we disagree, what I meant was, I think, agree. I do apologize.
So you do agree with him insofar as he said that it doesn't apply.
It does. The exception
does not apply to implied acquisitions.
Yes, it doesn't apply. Yes, it does not apply
you,
to.
You agree with that?
We would agree. We would agree that. Yes.
Yeah. Well, yes, I thought you'd say that, but
yes.
Help me on that. The section 13.3 provides the exception which we see that it provides. I'm just trying to turn it up. The exception is that nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of subsection 1, to the extent that the law in question makes provision for the compulsory taking of possession in the public interest of any property, or the compulsory acquisition in the public interest of any interest or right over property, where that property interest, etc., is held by a body corporate established by law for public purposes in which no monies have been invested. But if the position is, as appeared to be, the position we reached a moment ago, that the law in question makes provision for the compulsory acquisition of property, in that the minister can tell the corporation to do anything, and that could include transferring the corporation's property to the minister or anybody else without compensation. If that's what the law authorizes, it might be thought that to that extent, the law in question makes provision for the compulsory acquisition of an interest in or right over property, because the general power is so wide that it includes, but is not limited to, ordering the corporation to make a transfer, which would amount to a compulsory acquisition of an interest in or right over property. I mean, if the position is that the minister can by law order this, it would seem odd that he, if otherwise entitled, is not entitled to rely upon section 13.3, because he didn't say, I'm compulsorily acquiring your policy, your property, but I'm ordering you to transfer it to me for nothing.
My Lord, may I interject? I'm sorry, my voice seems to be a bit croaky.
Yeah.
I think the point here is that the corporation does not fit the description that is set out in that exception. What we say is the corporation is not, in fact, a body corporate established by law for public purposes.
Well, I'm sorry, that's a different point.
Yes.
I'm afraid I can only do one point at a time.
I'm sorry, my Lord, I misunderstood what you were saying then.
No. Well, did you understand what I was saying?
Yes, I did. I understood that. And I think this is the, I suppose this illustrates our previous discussion about the danger of these kinds of powers. and this is why I suppose it's perfectly, I mean, anything's possible. The answer is that if the minister has such wide powers, and that can be called deemed powers as well, then anything's possible. And this is why, looking at some of the evidence and the Hansard reports and so on that are in the record, you will see a number of individuals, members of the assembly, and the mayor and councillors calling this a potential land grab for precisely that reason.
Well, if what has been enacted is a potential land grab, which is the slang expression for the compulsory acquisition of property without compensation, then the law in question makes provision for that. And if the section is otherwise applicable, which we'll come to in a moment, if the section is otherwise applicable, it would seem to me it didn't cease to be applicable, because what the minister would have done is not in terms compulsorily to acquire the property, but in terms to make an order which has that effect.
Yes, I mean, I think that's that could happen. And I mean, what we would say about this is this: if that device is employed, under the present proposals, then that is possible. That may happen, but your hypothetical speaks to two issues. One, that the control is enormous. It's way up on the scale of fact and degree. And secondly, that it is despotic.
Well, that's true, but uninteresting so far as the present point is concerned. I mean, what I think the judge must have held, and you presumably support, is that this subsection acquires to the extent that the law in question makes provision for compulsory acquisition, and that must mean makes provision in terms for compulsory acquisition. In other words, makes express provision for what it terms compulsory acquisition, rather than makes provision for that which, when the provision is put into force, will mean that there is in practice a compulsory acquisition. Yeah, okay.
Yes.
Right, well, that's the issue on the first part of this subsection.
Yes. And the second relates to money invested other than money provided from public funds.
Yes.
And on that point, oh, sorry, I'm looking at on that point, we say that the money does not emanate entirely from public funds by any means. The test is not whether the money received become public funds, which the judge assumed, but whether the funds have been invested in it other than monies from public funds. In other words, it's the source of the funds that create the exception under section 13.3 and not the ultimate destination. Everything may become public funds, but as I understand it, and Mr. Myers would know more, the funds, I was instructed that the funds come from differing sources, as with all local authorities, not necessarily from public sources, from rental, from other fees and so on. May I ask Mr. Myers if that is correct?
Yeah, it is. The thing is, if there is no evidence, and it would be for the Attorney General to put evidence in, because this is an exception, this being an exception is for the Attorney General to demonstrate that it applies. And there is no evidence from anyone that demonstrates that the corporation is a body in which no monies have been invested other than public funds. There just isn't any evidence. We would say, though, I mean, beyond that, that the evidence demonstrates that that's not the case. That's not the test, but we would say we can show it's not the case, because all you have to do is look at the corporation's audited accounts, and you can see where all its monies come from, and none of it seems to be talking about public funds. Because monies come from rentals and parking fees, etc., etc. These are things that any landowner could make money from.
Yes, and the audited accounts are in the record. Do you have the number? Yeah, you can easily see that.
There seems to be another point floating around somewhere to the effect that the funds of municipal corporations were not public funds because of some exception in the Constitution. I picked that up somewhere. Is that pursued?
No, I think we had suggested that certain provisions of the Constitution relating to public funds would be what is meant by public funds in this particular provision.
Yes, well then we better look at the provisions of the Constitution that you rely on.
I think we're looking at section 39 to do with public bills called money bills. And public money.
Yeah, I'm going to have to try and
section
find...
Section 39 of the Constitution.
What?
It's section 39 of the Constitution.
Yeah, the slight problem is that the Constitution is not in the bundle.
Oh, I'm so sorry, my lord. We had been told that to assume you had copies of all the legislation.
We were asked to send them to your address yesterday. And they
well, I got a whole lot yesterday, but it didn't include the Constitution.
Really? I'm so sorry.
I mean, I've looked at the Constitution online. But I haven't printed out the whole thing because it's quite large.
Yes, that's right. Yeah. We did authorize that and instruct it yesterday.
Well,
I'm grateful for that. I would have been more grateful if the ordinances had come in chronological order. But unless I've been unlucky, the Constitution was not, I think, included in it.
No, it wasn't. I printed it out.
Yeah.
It wasn't in the pack.
I can only cover the head of my chambers in shame because they're normally, if I may say, very efficient.
Yeah.
Well, we shouldn't be looking at it in hard copy anyway, Professor Joel. We should be looking at it on the line. So don't yes. Apologize.
So what are we looking at?
Well, section 39.
Yes.
Which refers to money bills and defines a money bill as a public bill, which in the opinion of the speaker contains only provisions dealing with certain matters only. And then it goes on to say, and in this subsection, the expressions taxation, debt, public money, and loan do not include any taxation imposed, debt incurred, money provided, or loan raised by any local authority body for local purposes. So that is the Constitution drawing a distinction between overall public purposes in the broader sense and local purposes in the more narrow sense of municipal purposes.
Yeah, but that's only for the purposes of deciding what's a money bill.
Yeah. Yeah, I think the point we were making, my lord, is there is no specific definition of public funds for the purposes of section 13.3. And so reading the Constitution as a whole to see if you can find some clues as to what is meant by public funds, that's a clue that comes up. But even if that clue is not relevant, I think the short answer is public funds, I think quite clearly must mean government funds.
Okay.
I'm not sure what else that can refer to. And if that's what it means, then to the extent that the corporation is funded by monies other than monies coming from the government, it does not fall within subsection 3.
If that is so, that conclusion follows.
Right, but for the government, but for this exception to apply, the government would have to demonstrate that it has that the corporation is a body in which it has invested public money, and that is the only money that has been invested in the corporation, because the general principle is that it is for the government to bring itself within an exception.
Yes.
And I do not think that the evidence has demonstrated that at all. It's to the contrary, in fact, I think is the point. Yes.
Right.
I think one other point, my lord, that I would just like to make on this is that at the very least, what this subsection demonstrates is that the Constitution is intended to apply to bodies corporate established by law for public purposes. There has been some suggestion that because the corporation is such a body, that somehow the Constitution applies differently to it or ought not to apply to it. The point is, this exception wouldn't be necessary unless, in fact, the Constitution does apply to such bodies. And all the Constitution is saying is that it's only certain kinds of bodies of that kind which are outside of the property right provisions, i.e., those in which only public funds have not been invested.
Yes. I mean, the example you've given of the receipts of the corporation, rental and parking fees, are those that monies that can be regarded as invested? When I pay my parking fee, am I investing in the local council?
Well, that may not be the case, but I think the point is, isn't it for the government to demonstrate that there has been only investments of public funds in the corporation so that it comes within the exception?
Yeah, okay. Right.
And sorry.
Right, where do we go next?
Well, my lord, there are two outstanding issues, the two de bene esse ones which we could deal with now or not. I think we have in some ways opened the rule of law issue. It's a question, it's purely an argument from principle. I mean, I would say fundamental public law principle. I think I've made it and illustrated it to some extent, and to support it, I would refer to those cases that we've already seen that clearly supply the rule of law and the notion of legality and the notion of limited discretionary power and due process very much as an inherent quality of Bermuda and a number of other countries that have written constitutions and claim to rest on notions of human rights and human dignity and the rule of law. And I would cite and support the anisminic case together with its recent emanation, which goes even further, Privacy International, which I think by analogy shows that even in a country with a non-codified constitution, the courts are very reluctant to permit a body to expand its powers or to allow the executive or any public official or even the legislature to expand its powers to some extent that it is outside of the law, beyond the control of the law, beyond the control of the notion of vires, which is completely required as the most fundamental principle of public law, that nobody can simply expand its powers at the whim, or be ordered to expand its powers at the whim of the diktat of a minister. And I would cite those cases in support, and I would cite Lord Bingham's book on the rule of law, which is quoted at tab 44 and 110, paragraph 110 of our submissions, where he says it is an elementary principle that anyone purporting to exercise a statutory power must not act beyond or outside the limits of the power conferred. Here again, the principle is so old that it is known by its Latin name, ultra vires, beyond powers. It is common sense. If a head teacher has statutory authority to exclude a disruptive pupil for, say, 2 weeks, he or she cannot lawfully exclude a pupil for a month. If a local authority, here we come to it, has the statutory power to borrow up to £10 million, it cannot lawfully borrow £100 million. There would be little or no point in laying down legal limits if they could be broken without legal consequence.
Well, all that is self-evidently true, but to take Lord Bingham's words, changing them a little, if a local authority has statutory power to do anything which the minister orders it to do, statutory power, it can lawfully do what it is required to do.
As I said, there's an intervening act which says that local authorities only have certain powers. If you have
but
a
the
subsequent
legislature can
amendment
change that. The legislature has full power to change the law. The local authorities only derive their power from the legislature. Until the amendment acts of which you complain, its powers were limited, and they did not include that which is contained in the amendment acts. But when the amendment acts were brought into force, their powers changed.
So what you're saying is that they've expanded the vires.
The legislature has expanded the vires. I entirely accept. And I don't quite understand what relief you seek under this heading. What do you want us to do?
We would like you to declare it as contrary to the principle of protection of law and legality and rule of law.
To declare what contrary to the principle?
Well, at least that's statute, the 2018 statute.
Right. Okay. Now, what's the second matter we haven't dealt with?
Well, the second matter was...
Lord, I do apologise for intervening. Is it the whole statute or section 7AA1A? I thought under the protection of law, I referred to paragraph 111 of the skeleton argument.
Yes, it's the one that deems the power.
So I just want to be clear. I apologise to Sir Geoffrey for interrupting, but is it section 7AA1A or is it the whole statute?
It's the yes. Well, we would say that the provision that provides for the deemed statute, which is 7AA1A.
Okay, right. Just wanted to be clear. Thank you.
We would like that to be declared unconstitutional.
Right. Well, let's just assume we do that. We declare that the provision of Section AA1A of the Municipalities Act 1923 is contrary to the rule of law and stroke all the Constitution. Where does that get you?
We hope that at least that section will be removed or reduced.
Well, of course it'll be removed, but what utility is it? If the position is that the minister is by other sections entitled to direct the local authority to do things, how does it matter a hoot whether the provision that what it does is to be deemed to be for municipal purposes is there or not?
Well, he can do much more with a deemed provision. His power is infinite under the deemed.
But it's infinite anyway. His power is to order them to do anything.
I don't want to lessen the argument on control in any other respect. I do appreciate that it is a radical and very powerful form of control that he already exercises. It just seems to us that provision in particular allows a government to move into the realm of fiat and despotism in some way. I don't think I'm overstating that, but I say that advisedly. Whereas the other provisions are more in the area of custodianship or regulation. But this really, I think, passes goes beyond the pale in that respect, because it simply gives a power that means it's effectively could amount to a total takeover or nationalization, which has not been the path that has been employed.
Right. Okay. And what's the last item on the program?
Well, the last item on the program is the point about free expression. If your lordship,
oh yes,
that you would,
yes,
you would wish to hear it.
Well, we've said that we'll hear it de bene esse. Whether
Well,
we would wish to hear it is a different question.
May I raise it this way, that once again, if the inclination is, in this case, to feel that there's nothing, that under the notion of legislative supremacy, there's nothing much that can be done to bring back an electoral system that has been in existence for 300 years and allows the voice of the residents to be heard. And we would then, of course, the issue is not one of great. There's nothing much we can do. If it's seen in some way as a block on the opportunity of those individuals who actually reside in within the jurisdiction of the corporation, and it's those who have businesses there, a block on their opportunity to have a genuine and legitimate and real say in those that effectively govern them, then it is of huge import. And we say that the kind of action that has been taken here, actually to snuff out the entire electoral system, not to change it in any way, not to what the Americans call redistrict or redelimit the constituencies, as they did in the Canadian Toronto case, which is in our bundle. We've looked through the cases of the European Court of Human Rights to see if there's one instance that we can draw on, and we cannot find any. That is, and that in some way that weakens our case because we have no case on which directly to draw. On the other hand, it might strengthen our case because no other country, certainly in the whole of Europe or anywhere else that we've looked, and we've looked across the world for comparative cases, has gone to this extreme of the central government disagreeing with a local authority, clashing on many occasions. It's all in the record, policy after policy, whether it's parking or wharfage or development of the waterfront, whatever it might be. And they're saying, right, we'll first of all control you as much as we possibly can, and this has come out today. But secondly, we will silence you.
Wait a minute, it's important to work out who you is.
Well, you is the electors and the councillors.
Well, they can express anything. Well, let's take it in stages. The electors are the residents and the business ratepayers. Their expression is not reduced one iota. They can say what they like to whom they like.
But they can say what they like, but they have a mechanism now of a voice in the election of those who are actually going to govern them. They can choose. They have a choice. They won't have a choice of their councillors or their mayor.
But there are two different things. One is I haven't got the freedom to express myself. The other is I haven't got the choice to elect somebody who I want to elect. They may both be vitally important, but they are not the same.
Well,
I thought you were going to say, possibly, that there was a loss of freedom of expression because the councillors whom they elect must be regarded as their agents to speak. And if they're not going to elect them, they lose a right of expression through their agent.
Through their agent, precisely. But
Well, it's not how you put it before,
well,
I don't think, but that's what you say now.
Yes, I meant to mention that the kind of mechanism of their expression is both to they have electors, of course. In other words, what is at stake here is a form of representative government, and that is being dismantled. So these are their representatives. They are the councillors, and the mayor is the voice of those who vote for them. And that is the point on surely on expression. And
So Geoffrey, who's the right plaintiff on that? Is it the corporation or is it the electors and the ratepayers?
well,
Being deprived of the you say it doesn't matter anyway, I suppose, would you? But isn't in reality the people who are deprived of something is not the corporation itself, but the people who elect the mayor and the corporate and the members of the council?
Yes, the Section 1 of the Municipalities Act 1923 says as follows: the Corporation of Hamilton means the mayor and councillors of the city of Hamilton. So the corporation is not a sort of corporate entity, an abstract corporate entity. It is under the Act, it is the mayor and councillors of the city of Hamilton. It is they personally whose offices will be terminated. They must resign. And importantly, they represent the views of those who elect them. So the corporation means mayor and councillors. It is they who express policies on behalf of the electors. The electors vote for members, itself an act of expression, who make the policy on their behalf. And thus the corporation expresses the will of the electors. The corporation's voice is that of its electors. And that is the constitutional intent behind any representative democracy, and also I would say the practical reality. And for that reason, I wouldn't think that it is only the ratepayers or the residents that would have standing here, especially as when it is the voice of the corporation that the legislation seeks to subdue. And we would say that it seeks to subdue it by holding disproportionate means. The corporation is extant and its policies are being sought to be controlled. And the system of articulating its policies through the votes of the residents is what is threatened. I would also say, in terms of standing, that we're in a case like this, where a fundamental issue might not otherwise be heard, and there might not be others who are in a position to bring this case in the public interest, that the approach to standing must be broad, and it would be more than unfortunate if this really fundamental issue was to pass unexamined by this court. And I could provide case law on standing if you wished, but I think they're probably all very familiar to you. And these would, since the corporation is the councillors and the mayor, I think they can certainly act in their own interest and also as representatives. This was just been said.
Could we have a look at the latest decision of the Canadian Supreme Court?
Yes, indeed. I would just say about that, I mean, that is a case, as I mentioned, of simply, it's very simply put, the elections had already started. And then the government decided to alter the electoral districts. But there's no deprivation of voting. Everybody who was going to vote could still vote. They were just in different constituencies, that's all. So it's far away from this case. It's just an administrative issue. Since it had all begun, people thought that they were in particular constituencies. They'd related to their constituency members. They had worked within their constituencies. They'd knocked on doors in their constituencies. And then suddenly the thing was changed. You're no longer in Westminster. You're going to be voting in East London. So that's all that happened. And even there, the judgments and the ringing dissents, and it was very split courts on this. Even there was a great fuss and bother about democracy is being tampered with. So isn't this a matter of even greater outrage here, where a whole system of elections of people are being deprived of their vote in the area in which they live or in which they have businesses? This is a massive constitutional issue in any democracy, because it de-democratizes local government. There's no right to local government. We're not asserting a right to vote. We're not asserting that, but they're very linked. And if one looks at Article 3 of Protocol 1, which is the right to participate in elections, that provision says, yes, purpose of doing that is that you can express your view. And the cases, and I won't take you through this now, I see this more as an application for leave, but the cases very much link the notion of free expression with expression through voting. So,
sorry, where can we find this case? Where is it?
The Toronto case is at tab 54F.
Oh, it's one of the new ones, isn't it?
New ones.
I'm trying to find them on the cloud. Yes, 54F.
Hmm.
Right. Yes.
Um, so this is a case brought under the Charter of Rights. There's a head note on page 2 of 46. The City of Toronto municipal election campaign commenced and nominations open in preparation for an election day on October 22nd, 2018. On July the 27th, the closing day for nominations, Ontario, as the province, announced its intention to introduce legislation reducing the size of Toronto City Council. And the new act then came into force, reducing the number of wards from 47 to 25. And the city and two groups of private individuals challenged the constitutionality of the act and applied for orders restoring the 47 ward structure. And the application judge found that the act limited the municipal candidates' right to freedom of expression. So there it is, under section 2B of the Charter. And the municipal voters' right to effective representation. So those are the two rights, one equivalent to Article 10 of the ECHR and Protocol 1, Article 3, which is the right to effective representation. And he held that these limits could not be justified under Section 1 of the Charter and set aside the impugned provisions of the Act. And Ontario appealed, and the Court of Appeal granted the stay, and the election then proceeded. And then the Court of Appeal allowed the appeal, finding no limit on freedom of expression. It got tangled up in the Canadian jurisprudence's positive and negative rights. But ultimately, it was all a question of was there sufficient interference in the actual election? And as I said, since everybody who was initially voting, as I understand it, would continue to do so, they still could vote, but not in their own constituencies. That's all it was about. But nevertheless, a very, very powerful, there were very powerful dissents. And in the Supreme Court of Canada, I think it was it 1, 2, 3, 4 to 3, was that right? Yeah. 5 to 3. But 5 to 4, 5 to 4, yes. And while it is true that the Court of Appeal and Supreme Court found by majority there's no violation here, the question is whether the reforms would excessively dilute votes. The majority in the Court of Appeal, speaking for the whole court, held at paragraph 73 there, that it was a sound proposition that voting is expressive activity protected by freedom of expression. That voting is an expressive activity, section 73 of the Court of Appeal judgment.
So where did we find that?
That was is that the Court of Appeal? Court of Appeal, yes. Paragraph 73.
Well, sorry, is that?
Oh, that's a different tab, isn't it? Which one is that? What tab?
I'm looking at the Supreme Court or the
yes. In the Supreme Court, the majority explicitly held that it was not dealing with a case where the lawmaker acted with the purpose of interfering with free expression. But it held that an election campaign of 2 days would be too short for the effective exercise of free expression at paragraph 27. So at paragraph 27 of the Supreme Court, it was held that and there was no suggestion, it says 27 of the Supreme Court, there was no suggestion that the province acted with the purpose of interfering with free expression. And that's a very important difference here. And therefore we confine our observations here to the claim presented. That is a claim that a law has had the effect of substantially interfering with freedom of expression. And in our view, substantial interference with freedom of expression occurs where lack of access to a statutory platform has had the effect of radically frustrating expression to the extent that the meaningful expression is effectively precluded. While meaningful expression need not be rendered absolutely impossible, and of course in our case it has been rendered impossible, we stress that effective preclusion represents an exceedingly high bar that would be met only in extreme and rare cases. For example, a statutory reduction of the length of an election campaign to 2 days. So, although it's there's a high bar, there's no suggestion. I mean, it seems very clear that actually abolishing elections would certainly be regarded in this case as a breach of freedom of expression. There can be little doubt about that. And there's if one wants to look at the dissent of the great Justice Abella in paragraph 87, you will see there the kind of sentiment that I am trying to convey as being of high constitutional importance. I agree that she was in the dissent 5-4, but I hold her as a great judge. And she said in paragraph 86 to 87, elections are to democracy what breathing is to life. And fair elections are what breathe life into healthy democracies. They give the public a voice into the laws and policy they are governed by, and a chance to choose who will make those laws and policies. The point that I was just making, it's both a voice and a choice. It is a process of reciprocal political discourse. The rules of an election, including the electoral boundaries, and the timelines for campaign structures and process of reciprocal dialogue between candidates and those in their electoral district. The final act of voting, itself a form of political expression, is the culmination of the process of deliberative engagement throughout the election period. So that's the kind of value that's placed by the dissenting judge in that case on elections, dealing both with the voice and the choice, which is being wiped away after 300 years in Bermuda. And my submission is that it would be unfortunate if this honorable court were to not examine that with some care.
Why didn't the majority in this case think it was a deprivation of freedom of speech?
Because it was a rejigging of electoral boundaries. That's all it was. It's not near our case. And even there, it created a huge fuss and bother because people felt that somehow the election had begun as I said, they were knocking on doors in their own constituencies. They
Yeah.
were preparing, they had finance from their own constituents, and they were on their way. And then suddenly they're told, we're no longer in Lambeth, we're in Southwark, and start all over again. And they say, well,
It's pretty sharp, isn't it? Yeah.
Yes.
Right.
I could continue to talk about the justifications provision, the limitations of this right of expression. But perhaps I could just say this, that I don't think if you decide that this is worthy of consideration, if you decide that there's sufficient standing, if you think that our test, I haven't spoken about our test, we will submit no new facts. I think the facts simply speak for themselves. And in any event, much evidence has already gone in about this, little of which we've actually touched on, about the issues and the conflicts and the problems and so on. But if by any chance it is felt that there is a justification written into the section, I would say there is none. I think that the respondents would be completely blocked, because going back to the Constitution, the limitations on section 9, which is this section, are the following. Section 9 provides for protection of freedom of expression. Except with his consent, no person shall be hindered in the enjoyment of his freedom of expression. And for the purposes of this section, the said freedom includes freedom to hold opinions and to receive and impart ideas and information without interference, and freedom from interference with his correspondence. Then it provides the limitation section as authorized in section 1. Nothing contained in or done under the authority of any law shall be inconsistent with or in contravention of this section, to the extent that the law in question makes provision that is reasonably required. And here are the defenses. In the interest of defense, can't apply here. Public safety doesn't apply here. Public order, which has been defined in various cases, including in Bermuda, as grave breakdown of law and order, affray, riots, etc. Public morality would not come in, or public health. So I'm afraid that if it were held to be a breach of freedom of expression, the defenses, the limitation clauses would not avail the respondents one iota.
Right.
Perhaps that's enough for this application at this moment. There's more to say if my lords would want me to would give me leave and ask me to continue. But
I'm sorry.
I will not labour the point either way. We've seen many cases today.
Okay, well, I think we'll just retire for a moment, if we may, if we can have a breakout room. Quello?
You just retire to the judges' room.
Yes, please.
Do we switch off?
Yes, please, Sir Jeffrey.
Can you hear me, Jeff?
I can hear you, yes. I was one, and we have Mr. Coelho.
Are we all in? I think enough of us are. Jeffrey, I don't want there to be a misunderstanding. We are wholly happy to hear your submissions in relation to the freedom of expression point. When I said that we would consider the submissions de bene esse, what I meant was in the classical meaning of that phrase, that is, that we would consider them without thereby accepting that it was necessarily, without thereby accepting that there couldn't possibly be any bar to reaching a conclusion on the point. In other words, we wish to hear your submissions if, at the end of the day, we came to the conclusion that they couldn't be dealt with in the absence of giving the opportunity to the government to produce some evidence, we would say so. But I wasn't intending to shut you up or to close you down in relation to whatever submissions you desire to make in relation to the freedom of expression point.
I'm grateful for that, my Lord. Yes, thank you. I think we have, do we have 15 minutes?
Yes, we do. Is that convenient?
It's certainly convenient for me, and I'll try and do what I can within that period.
Thank you.
I'll try and close it. I think, right. So there are various issues here. The first one is standing, and I think I've mentioned that the definition, the corporation has already, in this case, been accorded standing. And to sue as a person under Section 15 of the Constitution. And there was no cross appeal on this issue. But in any event, as I said, the Municipalities Act provides that the Corporation of Hamilton means the mayor and councillors, and I think we've said enough about that. And in any event, I would refer to the case at tab 43, where the previous Chief Justice, Justice Kawley, said that that he would instinctively concluded at paragraph 34 of that case, tab 43, paragraph 34, instinctively concluded that it must be open to the applicants to seek to challenge the constitutionality of the impugned legislation in the public interest. I was and remain inclined to view that Section 15 should be construed in a broad and purposive manner, capable of embracing a claim by a public interest litigant. So he talks about a broad and a very liberal, in other words, a liberal approach to standing, which I would hope could be adopted here. In terms of case law, we've just mentioned the Canadian case, and I don't think I need refer to it again, except to say once more what I said earlier, that that is the closest case that we can find to this one. We looked at many jurisdictions and many countries under the European Convention, and we did not see one where a previously electoral system at the local or central level or at any level. There were occasional amalgamations at a regional level, but normally they weren't challenged because they were considered to, those, they never disenfranchised the people who were living there. And that's the big factor. They put them into a new system or a different system. There was no disenfranchisement. Now, as I say, we're not basing this case on the notion of the right to vote, but we are saying that it is a truncation of expression. We probably don't have to, under that view, prove motive, because the effect has been to disenfranchise and to still the voice and the choice of the inhabitants of Hamilton. But insofar as it is necessary to do so, if it is, we simply say that there have been a clash in policies which are well documented in the record. And if there wasn't this late hour, I would be able to show you all that, but it's very well documented also in the judgment, the various disagreements over time, which are set out in the judgment on matters, as I said, of parking, land development, wharfage, and so on. And the judgment paragraphs are 16 to 25, page 1197 following on the electronic bundle, 1197 following in the electronic bundle.
So Geoffrey, could you help me, please? Why are the facts relevant? Surely we've got to look at the bill and see what it's doing as a matter of principle.
Yes.
I mean, okay, that it's actually all very interesting for people interested in the history of Bermuda as to what they've been having disagreements about. But surely at the end of the day, we've got to look at the bill and say, is that depriving people of the right to vote? I mean, does it matter what the nature of the dispute is about?
No,
apart from being very interesting.
Yeah, what I tried to say was that it's the effect, absolutely, that counts. What it was prompted, motive may not be important. And the jurisprudence on Article 10 says that it can be motive. We're going to cut you out because you're a thorn in our side. But
say, for example, that the government actually thinks that it's a better idea that it should be running the wharf, the harbourfront.
Yes.
So it's got, I mean, that may be a perfectly acceptable, proper view to take, but it's the means by which they go about it, is it? That
well, it is indeed, absolutely. It's a disproportionate means. There's no reason why they can't create a quango, as a number of countries do, that take over the waterfront development. And you see this, all over the world, often financed by China and so on. And these are the development corporations that have been set up here and elsewhere, and they take over aspects of development within the local authority. But to abolish the local authority, you can also control it. There are different ways of doing it. It's disproportionate, I think, sums it up. And to do so by actually suppressing the voice and choice of the local electors entirely must surely be, I mean, nothing could be more disproportionate than that. You already control virtually all decision-making, as we've seen. Let's give away the deemed provision. Fine, do what you like. But then to go and say in the last item, we're not going to abolish the corporation. No, we're going to actually abolish the right to vote for it and have anybody except central government have a voice in it at all.
But could they abolish, on your analysis, could they abolish the corporation altogether under their statutory powers to create and then destroy?
Well, that's a very interesting question, and you can imagine we've discussed that among ourselves. And I see Mr. Myers has just come in view, and we were discussing that just a few days ago when he was in London. We wonder where the property would go. Because it's, for a start, I suppose it could go to the ratepayers. There's a fiduciary duty perhaps there. We struggled with that one. But I think if you are going to abolish the corporation, that's one way of going. You're nationalizing, in effect. Maybe, but you're not. That is not this case. You are keeping a corporation with specific objects and powers in place, which very much depends for its legitimacy, for its authority, and for its democratic qualities on.
Well, there's a problem with that, because you say it's not this case as to whether or not the council could be abolished, and you say maybe it could and maybe it could not. But if the position is that the council could lawfully be abolished, that would mean that such expression of anything as the council had previously made would fade away, because there would be no council to express anything. So if you could, in fact, abolish the council without offending the freedom of expression provisions, a fortiori, you could emasculate the council in the way that you describe.
I mean, is there a constitutional right to local government? I suppose it goes back to that question, doesn't it?
Not in Bermuda, not in the United Kingdom, not in a number of countries. But again, the issue is not that. The question is, where you have a written constitution that protects freedom of expression, can you do what the government are now doing? If I may say, it's a whole other question as to whether you can abolish. The question is, can you silence the existing voters under a constitution which entrenches freedom of expression? And that's the different kind of thinking in a constitutional democracy as opposed to an uncodified constitution. That's the very essence of it. And right, well, Mrs. Thatcher abolished the Greater London Council. You would take judicial notice of that, but I don't submit it in evidence. But she left in place the other local councils who took over. The voters just voted for their own council and not the GLC. So they remained in place. There were challenges even there, but there were challenges really nothing to this.
Well, I suppose you might say, park for the moment the question as to whether the council could be abolished, because it hasn't been abolished. But the question is, can you keep the council and silence those whom it's supposed to represent?
Yes, I think that, yes, with respect, I think that puts it very well. I think the whole notion of the council, its objects and its purposes as an elected council, rather than one that is, one has to see this again in the context of a constitution that does not permit that kind of action if it is sought to still and silence expression. I think I made that point. The case law, the cases that I seek to show you very quickly are only, there are 4 cases, but the one passage contains the relevant passage that I would like to refer to in the other. So if you would kindly look at, if I could take you to the case of sorry, I put Toronto in the wrong place and I misnamed the others. Well, we could look at the famous expression on is let's go to Handyside, paragraph tab 52, Handyside.
What's the tab, please?
52, 52, Handyside. This is the first case that really endorsed the notion of freedom of expression in the political area, what's called political speech. And the famous passage is on page 18, which is cited in so many other decisions of the ECHR. The court's supervisory functions oblige it to pay the utmost attention to principles characterizing a democratic society. So they put the context of free speech within democracy. Freedom of expression constitutes one of the essential foundations of such a society, one of the basic conditions for its progress and for the development of every man. Subject to paragraph 2, it is applicable not only to information and ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb the state or any sector of the population. Such are the demands of that pluralism, tolerance, and broad-mindedness. Again, this is a phrase.
Sorry, where is this? I got lost.
So this is on page 18 of Handyside, which is in tab 52,
Yeah,
and it's the first full paragraph. Freedom of expression, the court's supervisory function begins.
Well, I've got page 18 of tab. Oh, wait a minute. I'm sorry, it's the fact that the tabs, you have to go to the case before. Yes.
So it's page 18, which lays down the much quoted passage in terms of protection of political speech. The court's supervisory functions oblige it to pay the utmost attention to principles characterizing a democratic society. So it lodges the notion of speech within a democratic society. Freedom of expression constitutes one of the essential foundations of such a society, one of the basic conditions for its progress and for the development of every man. Subject to paragraph 2 of Article 10, it is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb the state or any sector of the population. Such are the demands of that pluralism, tolerance, and broad-mindedness, without which there is no democratic society. So pluralism is emphasized there, and therefore any formality, condition, restriction, or penalty imposed in the sphere must be proportionate to the legitimate aim pursued. And the only other two cases that I'd like to turn to are the case of here it is, Bowman and UK, which is at tab 54A. 54A. And then finally, I'll go to Barclay Brothers in Guernsey. That's the tab 54B. So tab 54A is Bowman and the UK, where the European Court of Human Rights held, when considering at paragraph 42, when considering the proportionality of restrictions on political donations, it was the issue there, that, and it starts at page 40, paragraph 42, free elections and freedom of expression, particularly freedom of political debate, together form the bedrock of any democratic system. The two rights are interrelated. So it shows there, that so far they're saying the right to vote or the right to participate in elections, which we're not really asserting, and freedom of expression, they are absolutely interrelated. And they operate to reinforce each other. For example, as the court has observed in the past, freedom of expression is one of the conditions necessary to ensure the free expression of the opinion of the people in the choice of the legislature. So they are saying these are two separate rights, the right to vote and the right of free expression, but they are interrelated because freedom of expression also seeks to guard the opinion of people in the choice of the legislature. For this reason, is particularly important in the period preceding an election, etc. And then it goes on to say the rights may come into conflict, but it's very important to secure the free expression of the people in the choice of the legislature. And then we get finally to the Berkeley case, which is tab 54B. And in that particular case, the Supreme Court considered the legality of changes of to the composition. It was a case in Sark. And the Supreme Court considered the legality of changes to the composition of the Sark legislature. This was the nearest analogy we could get. And all they were suggesting was that the legislature be increased, I think, by 2 unelected officers. The rest were all elected. This is tab 54B. And the claim was brought under Article 3 of Protocol 1, the right to vote. So the really question was only diluting the right to vote of the people by 2 appointed people, one of whom would be hereditary. There was no inconsistency with A3P1, because in the round and in the light of each state's own historical and political factors, but they said that freedom of elections and freedom of expression, particularly the freedom of political debate, together form the bedrock of any democratic system. They then quoted again Bowman. They said, it's terribly important, particularly freedom of political debate forms the bedrock of any system. And it does interact, but in this case, it was so minor, a bit like the Toronto issue, that we're going to let it pass. I've referred already to finally to the limitations on this right in section 9, and in my view, there is no limitation under which they could bring themselves, because the closest one would be public order. There's a hint in Mr. Duncan's submissions that administrative inefficiency could be brought under that ground. And my reply to that is certainly not. And there are cases that show that the definition of public order has to do with breakdown of law and order, affray, riot, that sort of thing. Certainly not a kind of administrative muddle at all, which could justify a whole load of residents to lose their votes on that ground. And there I would rest my submissions.
Thank you very much indeed. Has the Bermuda Constitution, that hasn't got anything equivalent to Article 3 of the first schedule or whatever it is, does it?
Uh,
As protocol.
no. No.
No, it hasn't, has it? No.
May I just say that I'm sorry, I didn't wish to interrupt, but that there are a couple of outstanding matters that you left Mr. Myers in particular to look at, having to do with Section 1 and so on, the Lex Specialis point, which he would be. I'll leave it to you to say it, Ronald.
My lord, I was hoping to deal with that tomorrow morning if possible.
Yes, I think that would be a good idea. We've had quite a long day.
Thank you, my lord.
Thank you.
Thank you very much. We will resume.
So, Chris,
yeah.
sorry, might we get a timetable from the parties, an updated timetable? Because I'm minded that tomorrow is the last day for this appeal, and then we have the public holiday followed by another appeal on Friday.
Well, we're going to be able to finish this tomorrow, aren't we?
I would hope so. So it's up to Mr. Duncan.
I think so.
I would hope so.
Well, that might be, I don't want to be unpopular, but that might be a stretch. There are two new arguments that have been added, the rule of law and the freedom of expression argument. So what originally was going to be a clear today, and I was hoping to start fresh tomorrow and try and canter through it. So I can't say any more than that. My estimate was based on the arguments that originally were in the appeal.
Well, let's see how we go. As I say, as Mr. Coelho says, Thursday's a public holiday. Friday we have a case. And if we didn't finish on Tuesday, we'd have to move this case into next week. Does that cause anybody any problems?
No, I would certainly make myself available for the court.
Okay, well, we'll meet at 9 o'clock Bermuda time tomorrow. Thank you very
my
much.
lord.
Thank you.